my lord. But I was not made a party, but I have filed my imprisonment petition, my lord, that has been registered. So I may be permitted to requisition that, my lord, and matter may be taken up at 2 o'clock, my lord.
Let us see what is the case.
There was
about.
some difficulty on my part also. In court number 1, division matter, Miller, the matter has been taken on the territorial jurisdiction part. It will take some time. At 2, if lordship convenient, if it's not inconvenient. At 2, no, obliged.
I may be permitted.
I beg to mention for listing a matter on Monday. I made a mention. My lordship was pleased to fix on 18 Friday, my lord. 18 is holiday.
Yes.
That again, man.
Okay, next week, someday.
On
Next
Monday.
week, silo.
Lordship,
New matter or old matter?
new matter, my lord.
Motion.
Motion,
Motion.
man.
Okay, motion.
May I please, Lordship? I have also filed a I in item number 10, Lordship, imprisonment petition.
Okay.
Okay.
Numbered.
Lordship,
Numbered.
yes, Lordship.
Okay, only if numbered, huh? Only if numbered.
Lordship, I would like to mention a read petition for orders for next week, Lordship.
What is your subject matter?
Subsidy matter, Lordship. It's a subsidy matter.
Okay, next week.
May I please, Your Lordship? I have to mention for listing one read petition. It's relating to settlement of market. Can it be on
When have you filed?
yesterday?
It will listed.
May I please, Your Lordship? Lordship, I beg to mention one item of 2016, Lordship. For final disposal, it has come up for disposal, but it could not reach Lordship. It is a bit urgent because of the petition. The case is related to non-payment of undue dues by the irrigation department. Long pending, Lordship, 2016 matter. Can it come up in the next week, Lordship?
Okay.
Deeply obliged.
May it please your lordship, I beg to mention 3 writ petitions for listing in the orders column for next week, lordship.
What is your subject matter?
Non-payment of outstanding liabilities of the respondent authority.
Needs to.
May please, the lordship. Lordship, I beg to mention for listing of 3 writ petition, lordship. Matters is relating to settlement of Mohol, lordship. Also,
Settlement of what Mohol?
Mohol, sand and gravel Mohol. Sand and gravel Mohol, lordship. 128.
Read petition is of the year
2023.
2023.
Yes, lordship.
Why it is not listed?
Lordship, it was listed earlier before summer vacation, and on the date on 21/6, it was directed that list after summer vacation, lordship.
Okay.
Admission. Obliged, lordship.
May please, your lordship. My lord, I'm paying for a listing of this matter on any day of the next week, my lord. Matter relates to, my lord, Benspur matter.
What is the subject?
My lord.
What is the subject?
Subject matter is, my lord, renewal of gun license, my lord.
Okay. Next week Friday.
My lord.
Also, item number 11. Yes, need. What is the IA about?
IA for lordship of change correction of the cause title.
Heard of this. Yes, Mr. Bora, IA.
I have no objection.
I am Hazarika Learned, Senior Counsel assisted by MS. E lawyer. Learned counsel for the applicant. And Mr. S. Bora, Learned Training Counsel. Department of Housing and Urban Affairs. For the both respondents?
Both the respondents. Lordship, both the respondents.
For both the opposite parties. The instant interlocutory application has been prepared, is prepared by the applicant, who is the writ petitioner in the accompanying connected writ petition, WPC number 4633 2023. It is ever that while preferring the writ petition, and in advertent error was kept in respect of the name of the respondent number one. Therein, full stop. It is ever that instead of the quote unquote state of Assam, comma, through the paragraph to the secretary to the government of Assam, comma, Guwahati Development Department, comma, Diskur, unquote. The respondent number one in the connected petition ought to have been quote unquote the state of Assam, comma, through the secretary to the government of Assam, Department of Housing and Urban Affairs, comma, Diskur. Full stop. The instant interlocutive application has been prepared for correction of the said inadvertent typographical error. Full stop. Mr. Bora, learned standing counsel. Housing and Department of Housing and Urban Affairs for the opposite parties has no objection to the prayer made in the instant interlocutive application. Full stop. I have gone through the amendments made in the application. Full stop. The error in connection with the name of the respondent number one in the connected petition appears to be an inadvertent error. And as such, in such view of the matter, command the interlocutory application is allowed to stop the registry to correct the clause title in the connected petition WPC number so and so, and also incorporate the change in the CS. Yes.
Lordship, the respondents invited a tender for providing drinking water house service connections. That was on 7/5/2023 at lecture 1, page 16. Lordship, pursuant to that, we submitted a bids. Altogether, 16 bidders submitted their tenders. And the bids were supposed to be open on 30/5/2023, but finally the bids were opened sometime in August, on 5th of August. Lordship, on 5th of August, I will take Lordship directly to the minutes of the tender committee meeting of the bid evaluation. Lordship will find at annexure 3, page 28. That's the minutes.
Yes.
Then Lordship, it's written the rate contract for providing drinking water is in lots of 5,000 each, total approximately 30,000 households in South Central and North Guwahati area, providing the requisite goods, etc., etc. The list of members present is in annexure 1. But annexure 1, Lordship, it has not been uploaded in the website. So we really do not know. We were not invited for the bid opening, even though we asked for it. Then, Lordship, they gave the calculation, how they are supposed to do the calculation.
It was e-tender.
E-tender. But bid opening, I'm supposed to be there. I have a right to know what is the bid.
No, normally bid the e-tender, I think it is open at the website.
But the website, the list is not there. I'll just show Lordship what happens then. Then, Lordship, it comes to page 29. They said after evaluation, 12 out of 16 bidders were found to meet the minimum requirements. 4 bidders who does not meet the requirement are these. They have named it. Details of evaluation sheet is annexed at annexure 2. As concurred by JICA, 6 contractors shall be on board through the parallel rate contract. Hence, basis on the details of evaluation, top 6 firms shall be awarded the contract for the existing items. The tender committee members gone through the evaluation and the recommendation following the top 6 ranks are given here. They gave the name of the top 6 along with the marks which they obtained. That is with the marks. And then Lordship will come to annexure 6. Annexure in the next page, that is annexure 2. Lordship, they have shown against me, which I am at serial number 4, I say they just write there's not in the sixth rank. Not in the sixth rank, and they reject my bill. Now, Lordship, this has been, it's the most, I do not know what marks have gained. I don't know.
Basically, it is annexure 2.
Annexure 2. Basically, I do not, I have a right to know. There's no transparency at all. Where I stand, whether the calculation is correct, whether I'm, this right.
Award has been made.
About Lordship, the notification that they will be aborted about as per at page
So
4.
rate will be same for all.
Rate will be same for all. Work
Only
and-
thing is that how you have qualified, in what
how
position you have
and
qualified.
how am I, where am I? This transparency is totally missing. It's all done behind my back.
There is a formula,
There's a.
so you have to examine that.
No, Lordship,
I think that can be provided.
Yes, Lord.
If
That
they have
formula-
asked us, we will have given to her.
we wanted.
I mean, the client.
I don't know my,
I think this annexure 2 is vital for you.
absolutely.
If marks calculated in a proper manner as per the formula,
Yes.
Look,
and if you
If I
come
don't-
below the top 6,
I have.
then
I
you are
have-
out of the game.
Absolutely. I have no quarrels on that.
That's all.
I just
Yes,
want to know where I stand. What is the marks?
So
where they were
basically,
calculated,
One
and
thing
the
is your marks.
and the
Secondly, how the marks have been arrived at. You have to examine that.
That
Only that you
absolutely.
can lay a challenge.
I know,
properly.
but unless I get the material, I can't.
Mr. Bora, can you provide the statement evaluation that is already prepared, annexure 2?
This
We
is
have,
prepared, but details are not there.
we have that. If they want lordship, they can let them file an application before us, or if lordship directs,
Let it
In-
come, let it placed before the court, Lordship. Let it be placed before the court.
or else we'll
Okay,
file
we'll issue notice, file a.
we'll
affidavit.
file and sort affidavit,
And,
disclosing
this-
everything.
Absolutely.
Yes, this will be subject to the outcome of the
Yes.
petition.
Because
This award 5/8/2023 will be subject to the outcome of the petition.
it
No,
has
let
been
it come
already
next.
given, they are not parties also. I'm not on that as of.
And that is another one.
That is
No,
another
Lordship,
thing.
no, I have no quarrel. I have no quarrel with these people. I may qualify, I may not qualify. That is one.
So we'll
point.
disclose it
So
before
I
this honorable
also
court.
let them disclose
affidavit.
before honorable court. I know
Okay.
where I stand. So once I know where I stand, if this 6 qualify, why do I unnecessarily drag them into the battle? I have no
Okay.
quarrel on that.
One week
Only
time
You are basically, at this stage, you are basically agreed by non-disclosure of the,
non-disclosure of the comparative marks.
okay,
And because I must know the marks, because I feel I have quite a,
that is limited.
It's a very short, 1 week's time maybe.
Okay.
next Friday?
Next Friday.
Third,
We'll file it before Wednesday or before
Yeah, so
Thursday.
that I can examine.
third,
Yeah,
MS M.
yeah.
Hazarika, learned senior counsel, assisted by MS M. lawyer, K lawyer, and Mr. D. Hoikia, learned advocate general, assisted by Mr. S. Bora, learned standing counsel, Department of
Housing and Urban Development.
Urban
Affairs.
Affairs Department for both the respondents. Full stop. Please take your seats. The respondent number 2 published invitation for bid for providing drinking water house service connections within bracket parallel rate contract by IFB number so and so, page 19, dated 7/5/2023. Full stop. The work description mentioned in the IFB was parallel rate contract, so and so, restoration all complete, page 19. As per the IRB, the last date of submission of bids was 35/2023, and the date of opening of the bids was also 35/2023. So stop. The bids were open, bids were however opened at a later date. So stop. Para 2.2 of the IRB had prescribed an evaluation criteria for evaluation of the technical bids and financial bids of the participant bidders Full stop. Para 2.2.1 was the technical evaluation criteria. Table con 22. The petitioner was one of the 16 participant bidders. Full stop. The tender committee in its meeting held on 18/7/2023 evaluated the bids of all the 16 participant bidders. Full stop. After detailed evaluation of the bids, the tender committee found 12 number of bids of 12 number of bidders meeting the minimum requirements of the IFB. Also finding 4 bids non-compliant, the tender committee rejected their bids. Full stop. After detailed evaluation, the tender committee, after going through the evaluation report, recommended the top 6 ranked bidders for award of contract on the basis of the marks they secured in terms of the evaluation criteria set forth in the IFB, and they were as under page 29. Pursuant to the tender committee meeting, the respondent number 2 has published a notification awarding the contract to 6 top-ranked bidders on 5/8/2023. Full stop. The petitioner is aggrieved by non-disclosure of its rankings and the manner full stop. The petitioner has contended that how the evaluation was made for ranking the bidders in terms of the technical evaluation criteria prescribed in clause in para 2.2 of the IFB are not yet made public. Any specific ground? Any specific ground of challenge?
Yes, Lordship, lack of transparency. Total lack of transparency.
It is a contention of the petitioner that the bidding process has suffered from lack of fairness and transparency. So we issue notice returnable next Friday.
It will be on Monday. By Friday, we'll file the affidavit.
Returnable on
28.
28.
Because tender is still not awarded, as far as this says only tender
It is
may be awarded,
it is a long process.
may be awarded.
No,
So this is,
this is basically empanelment of 6%.
Basically, rate is same,
Rate is
really
same.
same.
5,000 each connection.
Yes, this is empanelment, so they
Okay, if you qualify, some space could be allocated to you out of
absolutely,
500 connection from each of them. If
And
you
Lordship,
qualify.
they have a long way to go.
Returnable on
Lots of connections.
28/8/2000,
No, we'll have to
23?
remove the 6th one. The last one will go out.
28/8/2023.
Lordship.
The respondents, MS so-and-so, as Mr. Bora has appeared and accepted notice for both the no formal notice, extra copies during the course of the day. The respondents shall ensure that the counter affidavit is filed on or before 25th, 25/8/2023, including most of the respondents shall also bring on record the evaluation, detailed evaluation sheet mentioned as Annexure 2 in the minutes of the tender committee meeting. Also, the notification of award dated so and so is subject to the outcome of the repetition.
Highly obliged.
Numbers 1 and 2.
My lord, I'll argue item number 2 first, my lord. If item number 2 is answered, item number 1 will automatically be answered. Made previous your lordship, my lord. My lord, what had happened in this case, my lord, the challenge is made to an understanding of a clause, that is the viciation clause by the railways, my lord.
Understanding of a clause.
Because of
And
which-
understanding of a clause is not the subject matter of repetition.
My lord,
If your first statement is that understanding of a clause, because interpretation of a clause is not within the ambit and purview of Article 226.
my lord, I'll satisfy your lordship, my lord, that the.
So your first statement is that, so my
My-
first statement is that
May-
in response.
My lord, maybe I could not word it properly, my lord. Actually, my lord, what had happened, the meaning which they are trying to assign after completion of the work does not even remotely indicated in the contract agreement. I'll satisfy to your lordship. And hence, my lord, because I am basically here challenging a clause of a contract and a clause of a contract on 3 grounds, my lord. That the clause as it appears in the tender, in the contract agreement does not the meaning which they are trying to assign to that clause, the plain reading of the clause does not give that meaning, my lord. That is one. Number 2, assuming that the meaning is what they are assigning is correct, even then they cannot withheld my outstanding dues on account of this viciation amount because their own notification says it cannot be done. My lord will kindly, I'll just take your lordship to the brief fact. because-
First submission you made, that understanding or interpretation.
My lord.
Show me any decision of the Supreme Court that it can be done in Article 226.
My lord,
If you proceed with the submission, then I have to satisfy myself. Have you understood my
Absolutely.
query? So where is the law that I should interpret a term in a concluded contract?
Yes. My lord.
In a concluded contract.
My lord.
So any authority on that?
My lord, because I have challenged the very clause of the contract.
Right, that is why.
I'll take the lordship. sir.
Interpretation.
My lord,
So authority.
Yes, authority, my lord.
First, then we will proceed.
Yes, my lord.
First, you overcome that
Yes, my lord.
query.
My lord, I'll definitely take your lordship to the authorities. Your lordship will just bear with me, my lord.
Just one line, then I
My
will
lord,
proceed.
my lord, in 2019 4 SCC, there was a clause in a contract agreement which says if you want to invoke the arbitration clause, you'll have to pay 10% of, you'll have to deposit 10% of the claimed amount.
That is onerous.
No, my lord, that clause was interfered by the Supreme Court. Supreme Court says this is because since there are unequal bargaining power and therefore this clause is unconscionable and therefore Supreme Court has struck down that clause, my lord. Similarly, my lord, your lordship is that famous case, my lord, Brajanath Ganguly, my lord, that case where the Supreme,
Brajanath Ganguly,
yes,
that Inland Water
Inland,
Corporation
inland.
case 2012,
yes,
that is regarding service. The
Yes, sir.
Supreme Court has said,
my lord.
interpret that this Brajanath Ganguly will not apply in a tender matter where the two parties have signed the contract with open mind. So this unconscionable issue in Brajanath Ganguly will not be applicable in a contract matter. There are decisions to that. So Brajanath Ganguly, this two man of Inland Water Corporation who served for 9 years, this is an unconscionable contract. That is in respect of 14, where in a contract, once it is concluded, Article 14 does not come into picture normally.
Right.
Ordinarily, unless it's very good ground is made out. So this Brojanat, show me this Brojanat has been applied in contract matter.
My lord. My lord, in 2019 for SCC, because yes, my lord, Brojanath Ganguly followed by another LIC, there is a judgment that the proposition laid down in Brojanath Ganguly is in respect to service jurisprudence, my lord. However, my lord, the ratio which is laid down that when there are two parties which have unequal bargaining powers, and if there is a clause in the contract which is per se unconscionable, notwithstanding the fact.
So that is why show me the authority that contract matter Brojanat Ganguly concept.
2019. My lord, if you lord, I'll show that, but my lord, if you lord
Well,
allow
first,
me-
let me understand the law
Absolutely.
you are arguing.
Because there are 4 grounds on which I am challenging. Not only that it is unconscionable, that they are trying to defy their own notification. My lord will see that the
Which Brojanat Ganguly is applied in
My
which
lord,
contract matter? Which
will-
contract matter?
My lord will kindly come to the 4th citation of that is 2019 4 SCC 401. Which in my compilation at page number 129, my lord will see.
Now, let us see the facts of this.
Absolutely, my lord. In this case, my lord.
1 minute story. First, you have to know the story to understand the ratio. Let me find out.
There are 3, my lord. This as well. Like 10% call deposit was asked for, my lord, in this matter for availing arbitration, and it is found that this is discouraging the arbitration in that context, my lord. That judgment was delivered.
Para 11.
My lord. As has correctly been argued by the learned counsel appearing on behalf of the respondent, this court's judgment in Central India, which lays down that the contract of adhesion, that is contract in which there is an unequal bargaining power between the private parties and the state, are liable to be set aside on the ground that they are unconscionable, does not apply where both parties are businessmen and the contract is a commercial transaction. In this view of the matter, the argument of the apparent based on this judgment must fail. My lord, para 15, my lord.
ABL, you want to rely on ABL.
My lord,
ABL International, para 15, para 15, ABL.
It's ABL, my lord, the observation which has been made that this court has held that even within the contractual spare,
Right.
the requirement of 14.
When it is para 40, when it is
When it to act fairly, justly and reasonably by person who are state authorities or instrumentalities.
now, in what context ABL has decided that? In what context ABL has decided that? That is, I think, 2004 3 SSC.
ABL is 2004 3 SCC 553. Para 53 of ABL is also quoted, my lord. My lord, if your lordship just allows me to place the facts, my lord, probably, my lord, I'll be able to satisfy your lordship that this matter calls for an interference under 226, my lord.
We'll see to that. Let us seek a law.
My lord,
We have enough time to hear you.
absolutely,
Nothing to worry. You have enough time.
absolutely. I'm so happy.
Which paragraph you are relying of paragraph 15?
Paragraph 15, ABL, para 53.
From the.
So in what context Article 14 will come in your case?
Absolutely, my lord.
In what context Article 14 will come in your case?
Yes, my lord, here what had happened in this case, my lord.
This para 15 only?
Para 15 and your lordship.
Anything more?
Yes, my lord. My lord will see para 19, what was precisely under challenge in this case, my lord. Para 19. A clause of an NIT was under challenge.
No, clause of a contract.
Contract, my
No,
lord,
two things are different.
Arbitration contract.
Two things, Mr. Biswas. There are two things. One is the process leading to the award of contract.
Yes.
And after emergence of the successful bidder, there will be a contract executed between the successful bidder. After execution of the contract, he becomes the contractor. He no longer remains the successful bidder or a bidder. Thereafter, it becomes a concluded contract.
Right.
Concluded contract. Then comes all these principles 298 to Article 299.
my lord, in some of the contracts, my lord, the requirements which are there in the NIT, subsequently after the award of the contract, those become a
So
part.
your first judgment, that is Brojanath,
My
is not applicable. It is clearly laid down.
my lord, that-
There, no question.
so my lord,
Cannot be any question on that.
here, my lord, that AB, the present judgment which I'm relying, I'll just, my lord, before going to the fact, my lord, para 28, the last para, if your lordship sees. That would probably make it.
There are 27 also.
Page number 142, para 28. For all these reasons, we strike down clause 25.
Oh, this is NIT. This is NIT. Okay, you have made my thing easy. That which I explained. Because scrutiny at the stage of NIT is much higher. Court can examine the issue much higher. You go through Nobel Energy also.
My lord, the clause of the NIT.
Once execution is done, that is a different aspects altogether. Jagdish Mandal and everything, Article 14 remains at a distance.
My lord.
Then you proceed, because I am making my contours clear. Now you proceed.
My lord, when an NIT, my lord, when an NIT is invited, my lord, there are certain requirements in the NIT. These requirements subsequently, when the contract is awarded and the contract agreement is executed, my lord, there are umpteen number of departments. What they do is that they incorporate the clauses of the NIT in the contract agreement. The requirements in the NIT subsequently gets incorporated in the contract agreement, and they will add one line that the requirement in the NIT will be a part of the contract agreement. In this case, my lord, because the arbitration clause was invoked, my lord. Definitely, my lord, arbitration clause would not be invoked at the stage of the NIT. But the requirement that you will have to deposit 10% of the claim was a part of the NIT. Therefore, my lord, after that, my lord, because your lordship will see the challenge here is regarding deposit of 10% of the arbitration amount. And that requirement was there in the NIT. Para number 27. Before parting to an arbitration for invoking this alternative dispute resolution process by a pre-deposit of 10%. Para 27. Would discourage arbitration contrary to the object of the clogging of the court system and would render the para 27.
Tell your case
My lord,
first.
absolutely. My lord, the facts in this case are not disputed by either of the parties, my lord. My lord, here was a contract was allotted to me by letter of acceptance. Page number 22. I'll just run through the facts, admitted facts, my lord. Page number 22, my lord. This is the letter of acceptance for this work, my lord. This work was initially allotted to me for a total amount of 18 crore 74 lakh 69,000. And my lord, the work was for that Bhogibil project, my lord, in Dibrugarh, my lord, railway project, my lord. That's the project. Now, my lord, admittedly, the work was completed and a completion certificate was issued. My lord may see it at page number 102. This is to certify that such and such has completed the work.
What is the contract agreement?
My lord, the contract agreement, your lordship will find at page number contract agreement, my lord, page number 30. Now, my lord, after completion of the work, my lord, the railway have seen that, my lord, there is a negative variation. My lord, suppose they have issued the tender for executing 100 units of certain item, my lord, and after execution, it has turned out that what was actually required was 70 units, my lord. Therefore, my lord, if your lordship kindly comes to page number 103, there was a variation in the contract, my lord. And this variation was a negative variation on the minus side. And therefore, though the total amount of the work was 18 crore 74 lakh 69,000, it has scaled down to page number 103. The revised value had come down to 12 crore 86 lakh. So there was a total minus variation of 31.35. So, my lord, the entire dispute arose at page number 103. 103, my lord, will see the bottom line. This is for your information and requested to obtain no objection certificate from the contractor to recover the vitiated amount of rupees 26,21,881. They are saying that the vitiated amount, this is where is the bone of contention. Now, my lord, I did not find in the contract agreement a single clause which speaks of any vitiation amount. What is there in the contract clause is a vitiation clause. Now, they are saying that 25 odd lakhs need to be deducted from our total bill on account of vitiated amount. They are using this term vitiated amount. Now, my lord, here I take a pause and I take your lordship to the clause 6 of the contract agreement, which is at page number 53. Clause 6, my lord, down below your lordship is there, my lord. Viciation of contract. It says the contract shall not be vitiated by any inadvertent error of any kind in the surveys, information, specification, drawing, or schedule of quantities. However, during execution of work, if variation of quantities against them of work become inevitable, and such variation cause vitiation of the contract, the amount of vitiation will be deducted from the contract bill. Now, nowhere in the contract agreement it is explained that what is this vitiation amount. Because, my lord, the plain English word vitiation, my lord, I tried to find out the meaning of vitiation from 3 dictionaries, my lord, 2 legal dictionaries and 1 this Oxford dictionary, my lord. Nowhere the word vitiation even remotely gives an indication, indication that vitiation has nothing to do with amount, my lord. Vitiation simply means to spoil or reduce the effect of. That if because of any faulty survey, tomorrow it turns out that there has been some faulty survey, the contract will not be vitiated. I will have to execute after the survey is made good. The
You
contract.
can scale down the voice also.
Oh, sorry.
It is not required to be argued in such a manner.
Absolutely. Absolutely. I'm sorry.
I am hearing.
Oh.
Yes.
Yes. So, my lord, this now, what meaning they are trying to assign to this vitiation clause, I have tried to
Let us
explain.
see 103 first.
103, page number 103.
This is final variation statement.
My final variation, that after the contract is completed, my lord, whether there is any increase or decrease, whatever variation was there in the work, variation, and it has found out that there is a negative decrease.
So it is with your consent.
Yes, with my, they have, the value is 12.
No, this statement running from page 104
Yes,
to 108
absolutely. Absolutely.
is according to your consent.
Yes, there is no
right?
dispute.
Contractor.
Yes, my lord. There is no-
Now come to page 107.
107.
Last few rows. As per CA contract agreement amount 18 crore 74 lakh 69,000.
Absolutely.
Now required amount 12 crore 86 lakh 54,568.
Absolutely.
So variation in amount is lesser 58 lakh 81,000.
Absolutely.
Let us see what is the contract terms about this.
My lord, we are not disputing on
Let
variation.
us see the variation. What is the variation?
My lord, variation. Page 41, 2.8.
2.8. Now come to
my lord.
this note
Page,
in bold, page 41.
page 41. Yes, my lord.
Note 2,
Yes, my lord.
provision for reduced payment
Yes, my lord.
as envisaged in subparas 1 and 2
Yes, my lord.
shall be the minimum benchmark for the items where CA rates are banned for future reference owing to abnormally high rates, and where execution of quantities is restricted as per CA condition. Railway reserves the right to negotiate fresh rates for executing the variated or what?
Yes, very.
Quantities for such items beyond so and so or restricted quantities,
Yes, my lord.
as the case may be,
Yes,
over and above the rates of reduction of rates envisaged in subpara 1 and 2 above,
yes, my lord.
right?
Yes.
So restricted quantities.
Yes, my lord. There is,
There is a clause. Now come to 103 again.
yes, my lord.
Read the first 3 lines.
Yes, my lord.
TAO Con NF Railway Maligaon
Yes,
with the vetting of associate finance has
Yes.
approved the final variation statement
yes,
and accepted the TC recommendation after conducting negotiation with the contractor
yes,
towards final variation statement against so and so with a
Yes.
revised value of rupees so and so.
yes,
This is a statement,
yes,
right?
yes,
You have, there was negotiation,
yes,
then this has been arrived at,
yes,
right?
yes,
And this particular clause 2.8,
my lord.
if you read by 1 and 2,
Yes, my
Right.
lord. Yes, my lord.
1 and 2 will be also applicable in case of
Absolutely.
reduction of quantities.
Absolutely. There is no argument on that matter.
So if increase in quantities actually exceeded
Yes, my lord.
is between 25 to 40
Yes,
of the CA quantities,
Yes.
payment for additional quantities beyond
yes,
so and so will be made of the originally agreed rate.
Right.
As per note, this will be applicable also in reduction of quantities.
absolutely.
Then come to
Yes,
the page 107.
7.
So agreed variation, admitted variation is 31.37
Absolutely.
in negative size.
Absolutely.
So you are entitled for this much amount.
Absolutely.
So how much was
My lord,
reduced?
that is where, my lord, if my lord will kindly bear with me, my lord. There is no dispute on this amount.
So you gave that amount.
My lord, it's my.
You have done a work.
My lord
This
will
for
my lord will
2.8.
kindly bear with me for some time, my lord. There is no dispute on the variation part. The dispute is on the viciation part. There is nothing, my lord. The contract was for 18 crore. Then after execution of the work, it has come down.
First and foremost, you proceed. You can proceed for 1 hour, 2 hours. First and foremost, this is a clause, arbitrable clause. It cannot be
Yes, correct.
agitated in a writ petition. Very
Clause
much
55.
clear about that. I am very much clear about that. You proceed.
And arbitration clause is clause
My
55.
lord, arbitration, my lord, because my lord, when this matter was moved at the motion stage, because my lord, it has come up after.
I do not know for what reason. It is kept pending here.
Now, my lord, I'll satisfy, I'll try to satisfy your lordship that if the matter is once hard on merit, my lord, then alternative remedy probably cannot be invoked, my lord. I'll satisfy, my lord, I'll just, my lord, I'll tell the facts, my lord. The contract was for 100 rupees, my lord. After execution, it turned out to be 70 rupees. No dispute on that. I will get 70 rupees. But my lord, this 70 rupees which I will get, definitely I will get this 70 rupees. The items initially, my lord, 100 items has to be executed because the survey was done by them. Then after the completion, my lord, it turned out that the items required were 70. I am entitled for payment for 70 items, not for 100 items. I agree to that. But the items will be paid at the rate quoted by me. How can they pay me the item at the rate quoted by a rival tenderer whose tender they have dismissed?
Okay.
This is
Now
my
come to 107.
my lord. Yes, my lord.
So final variation statement states that you are entitled for an amount of rupees 12 crore 86 lakh 54,000 568. How much you have got?
Now, my lord,
According to you, how much
my lord,
you have been disbursed?
yes, my lord,
Now, let me also, this is also factual part.
absolutely. But I'll try to give that. But there is no dispute on this 12 crore.
No, how much you have got?
How much?
When a court makes a query, you should point out, or I'll throw your petition.
I'll try to, my lord. Lord, I'm sorry, my lord, that detail I'm not having, my lord. I'm extremely sorry that how
So
much.
you are arguing on all these legal points, but you have to be sure about your factual part.
My lord, my lord, I am not disputing on the 12.
No, I have to decide
My lord,
the writ petition.
my lord,
First, I have to know what are the factual background.
absolutely.
So how much you have got
My lord, that's
received? You are not penniless. They have disbursed something to you,
absolutely, my lord.
right? What is the amount? This 25 lakhs
Yes, my lord.
appearing in page 107,
My lord, 10.
right?
Yes.
They have made mention of something. Now, what is the amount you have received? That much I have to know.
My lord, my lord,
Am I clear?
absolutely, my lord. That out of,
From what amount they have deducted this 25 lakh?
they have not deducted as yet, my lord.
You know about the figure from where this 25 lakh is going to be deducted. They contemplate. They have not been deducted. They have not deducted, but they are contemplating.
My lord,
From what figure? Which figure? 18 crore or 12 crore? Tell me something
12
about
crore,
that.
12 crore, 12 crore. 12 crore is the after variation, 12 crore is the total value of the contract. Which has
That
come
much
up.
I am asking.
Absolutely.
Don't try to divert this way or that way.
No, my lord. They are from 12 crores. Because, my lord, we are also not disputing that it is an admitted fact that there is being a minus variation. The bone of contention is vitiated amount.
To come to that vitiated amount, I have to know the figure, how the things have traveled.
Absolutely.
You have straight away have gone to clause 6,
My lord,
but I want to know the facts.
my lord, my lord.
This variation, how much is the contract value? That final variation statement,
Yes.
thereafter, what figure has been arrived and from which amount they are contemplating this vitiation
My-
amount.
My lord.
That much I
Absolutely, absolutely.
have to understand.
Absolutely.
I am not as sharp as you.
No, but absolutely.
Am I clear?
No, my lord,
So you please provide me that the factual details.
absolutely, my lord. My lord, the total contract was.
You are straight away jumped to Brojanar Ganguly. It is not the case. Don't, when the law is clear that Brojanar Ganguly is not applicable in tender matter, don't make it. You are an officer of the court also. Is it not?
My-
You are not only the espousing the cause of your client, you are also an officer of the court.
My-
So Brojanar Ganguly don't apply everywhere. Unconscionable part is in service jurisprudence. They have not made it applicable in many judgments. Even your judgment, which you have cited, this is not the law. And tender is, there are two parts. Article 14 is prior to execution of the contract. After execution of the contract, Article 298 comes into picture of the Constitution, not Article 14. It is not everywhere, Mr. Vishwas.
No, my lord. The contract was for a total value of 18 crore 74 lakh 69,000. After variation, the contract amount was revalued at 12 crore 86 lakh 54,574. Now they are contemplating to deduct this 25 lakhs from the revalued contract value, my lord. Now, my lord, what they are essentially trying to do, my lord, I have tried to demonstrate that at page 11, my lord.
So come to page 110.
110. My lord.
Okay, this is Fishery.
Vitiated.
Now come to page 111. What is this?
111.
Let us read this one.
My lord. 111 is a letter
Let
written.
us read this
My
one.
lord, my lord. The letter of acceptance of the above stated work was issued wide letter of acceptance number such and such, and subsequently CA number such and such was executed with a face value of rupees such and such, my lord, with date of completion up to such and such. The work is for, the name of the work, my lord. In course of preparation of estimate tender schedule for above cited work, the provision of bouldering, pitching in slope, surges create in toe, laying of the filter material and grouting over boulder pitching was kept by keeping the same profile and configuration as like in US side dike. The main reason for keeping the same profile and configuration as provided in US side is due to the fact that the DS dike was under severe attack of the river Brahmaputra, and in the year 2006, severe breach in dike had taken place, due to which number of village was flooded and got submerged. During that period, the approach embankment was not constructed inside the river Brahmaputra fully. So during that period, the flow of river was towards the dike, and dike was under severe threat of breach and damage. So to prevent dike from any damage and breach, the provision of bouldering, pitching in slope, sources create in toe, laying of filter material and grouting over boulder pitching was kept in same profile and configuration as like in US side dike. But subsequently, the approach
Okay,
embankment.
Please come to 112.
My lord. Yes, my.
112.
Yes, ma'am.
Yes.
Therefore, my lord, which part?
First,
Therefore, item number 4, 5, 6, 10, and 12 were executed for the requirement at site, and for which less variation was involved. Due to less execution of these items of work, savings were made in the following items. Savings. Due to non-execution of the balance quantity of the work, railway could save the amount of rupees such and such crore. The main reason for the involvement of the viciation are discussed below.
you should have taken me to this first.
Yes.
Very first, to understand this concept of viciation. You have taken me everywhere, but not to this page. Yes, I have understood now this MK Dhiromol and Zoilal Singh Sanghi.
My lord.
Why they are resorting to some kind of viciation, or
Yes.
what may be the concept correctly or not correctly, but at least I have to understand. I have heard it for the first time, viciation concept. You should have taken me to this one instead of Brothanath Ganguly at the very first statement. They have explained everything. Now, whether this is correct or not correct, that is to be seen. But they have explained in this statement elaborately. Now, what is this SOP? What is this SOP?
Now, my lord, this SOP is, your lordship will find at page number 60.
Now come to page 113, 5.
my lord.
The contractors are given no.
You have given no claim certificate.
Yes.
The final variation amount decreased. The final variation amount decreased beyond 25% from the original CA value as per SOP 21.20 provision. This contract may be treated as a single tender. Their letter
1, 2, 3, 4, 5.
one,
5.
the decision for reduction in quantity of works stated such was purely on administrative reason downstream of dike. 5, the contractor has given NOC. NOC for variation, my lord.
No, 113.
He?
113.
Oh, 113 NOC for variation. That the work was 18 crore, now it is 12 crore. That
What is that?
No,
Oh, do you have the copy of that?
my lord.
Do you have the copy of that no claim certificate or annex part of this record?
My lord, I have not.
Because this is after elaborate discussion,
Correct. my lord.
this fishery amount 25 lakhs,
Yes.
so and so.
Yes.
Thereafter, it followed that contractor has given no claim
No claim
certificate
certificate. my lord. Yes.
and the copy of which is enclosed. So you have the copy.
no, my lord, this
No.
because
This nobody has.
because my lord, they
Nobody has for inspection of the court.
my lord, they can
Provision of so and so is reproduced below for your ready reference. Let us see the provision 114. Read 114.
114, my lord. The provision of 2021 SOP is reproduced below for your ready reference. Decrease in quantities of item, railway board letter, full power in respect of such and such, full power in respect of contractor accepted by them, full power in respect of contractors.
Now,
No,
who is the person here, officer here?
Deputy Chief Engineer, DYCE, Deputy Chief Engineer Con. Is right,
Deputy Chief Engineer.
yes. Deputy Chief Engineer Con is
4,
right.
5 or 6.
My lord.
In the table 114, there are authorities, powers delegated to officers in construction organization.
Yes,
Column number 4, column number 5, column number 6.
my lord.
Who is the officer responsible here to do all this?
CAO is the Chief Administrative Officer.
Okay.
And
This letter is written to whom?
my lord, this letter is written to the Chief Engineer by the Deputy Chief Engineer.
CE,
CE,
Chief Engineer.
yes. By the
Let us
Deputy,
let us read the note.
yes. For decrease in quantities of individual item up to 25% of the quantity specified in contract, no finance concurrence is required. For decrease in quantities of individual item beyond 25% or decrease in contract value beyond 25% of the original contract value, finance concurrence and no claim certificate from contractor is necessary. It should be certified that quantities proposed to be reduced will not be required in the same work at a later stage and will not hamper the state of work. Now, my lord, 4 I am relying, my lord. It shall be ensured that due to decrease in quantities, tender is not vitiated. In case of vitiation of contract, sanction of competent authority with finance concurrence, a single tender should be obtained.
Come to clause 2.
For decrease in quantities of individual item beyond 25%. Or decrease in contract value beyond 25% of the original contract value, finance concurrence and no claim certificate from contractor.
We are dealing with 31.37%.
Yes,
So it is beyond 25.
absolutely,
So finance concurrence and no claim certificate from the contractor is necessary.
absolutely.
Is
We
it
have-
not?
We have given
So no claim is there
No.
from your side.
no claim for the vitiation. 18 crore became 12 crore. We do not have any.
No, that is variation.
It is. This
That is
My
variation.
lord,
Now, this is vitiation.
no, my lord.
Is
we
it
are-
not?
No, my lord.
Yes.
My lord, that is where, my lord, we are variation and vitiation. We have no objection in variation. 18 crore became 12 crore. We have no objection because the item required was less. We cannot claim for more items, my lord. What we are saying is that how will you pay us at a rate quoted by somebody else? Please pay us. Please pay us on the rate quoted by us because you have accepted my tender based on the rate quoted by me.
And what purpose you have annexed this annexure 7
Annexure 7. Annexure 7 is a, my lord,
regarding variation?
regarding vitiation. Here,
Vitiation.
vitiation. But if my lord will kindly come to page number 107, last part,
117.
17.
Yes,
Clause C.
clause C.
My lord is there, man.
Yes,
In case where decrease is beyond 25% or above 25% of the accepted cost. Here is a case which is beyond 25%, my lord, decrease. Now, these all the railway need to do. The contractor authority can decrease, the contracting authority can decrease the item up to 25% of individual item without finance concurrence. For decrease in items beyond 25% of individual item or 25% of contract agreement, the contractor authority can do so after obtaining no claim certificate from the contractor and with finance concurrence given detailed reason for such decrease in quantities. It should be certified that the work proposed to be reduced will not be required in the same work. It should also be ensured that due to decreased quantities, tender is not vitiated. If there's a decrease, there will not be any vitiation. And in case of vitiation of the
should
tender,
also be
the last line.
ensured that decrease quantities tender is.
not vitiated.
Now, what is the concept of vitiation?
Yes.
This concept of vitiation is there
No, my lord.
and at least there in their terminology. This is a circular.
Yes.
That concept of vitiation is there. It is not that it is not there.
Now, my lord,
Last
the
line, in
last
case
line.
of vitiation of the tender,
sanction of the
sanction of the so and so should, it is not an alien concept,
Yes.
right?
my lord.
Question is how it is used. That is the, but it is not an alien concept.
My lord,
Clause 6.0 also makes mention about vitiation,
vitiation,
but we do not know how this is going to apply in your case.
my lord,
But it is not an alien or foreign concept.
my lord. My lord, in case of vitiation of tender, the last line, my lord, I am relying on this last line. In case of vitiation of tender, sanction of the competent authority as per single tender should be obtained. So clause C, which
Now,
deals,
what is this concept of single tender?
yes, I'll try to explain. My lord. If there is a single tender, my lord will kindly permit me to address on what the word vitiation, the word vitiation which they are trying to mean. My lord will
We
kindly.
come to understand that, Mr. Biswas, I am from the very beginning, I am asking you that please go to the provision, then you make your submission on vitiation.
My lord,
Why it is not applied,
My lord.
the concept of vitiation.
my lord.
Now, what is single tender?
My lord, if there is a single tender, then there will not, suppose three of us have bidded for a particular one. Now, my lord, if there is a decrease beyond 25%, then this tender, it cannot be vitiated because the entire concept of vitiation is trying to compare the rates with the other tenderers. So if it is treated as a single tender, then they will not have any other tenderer with whom they can compare the rates. The entire vitiation concept which they are trying to impress upon this court, my lord, is that X quoted a particular rate, my lord. This is in a tabular form, my lord, at page number 11, my lord, at page number 9, if your lordship kindly comes, my lord, it will clarify what vitiation they are trying to do, my lord.
What is the concept as per railway?
My lord, page 9, my lord, will kindly come. This page 9. My lord, is there.
This is your concept or railway's concept?
This is precisely what is railway's
Huh?
concept.
This is his concept.
It is. his
My lord,
concept. We'll
I,
come to your concept, whether any concept of
it's not there.
from the railway side.
It is not there. That's my case, precise case. That this is the meaning which they are trying to assign without there being anything in the contract agreement. My lord, in their affidavit, they do not deny my concept, my lord.
Hey, Mary. Now, where is the concept of viciation in railway?
Yes.
What is,
My lord.
where is that
My lord.
in existence?
So far, my lord, that viciation is concerned, my lord, that in all circumstances that my lord, L1 rate should be. at
No,
the
there
end
has
of-
to be something
Yes,
on,
yes.
in black and white.
My lord.
That
And,
this is the concept of
my
viciation.
lord, again, my lord, page 53, my lord, clause 6.0, my lord,
That is simply
Second line.
mentioned.
second line, my lord, yes. it
I
is
have
in-
seen, I
yes.
have read.
Yes. My lord, here, my lord, in the affidavit, we have stated,
So in the affidavit, you have stated, but where is the concept of viciation exists?
and so far that concept is concerned, my lord, I have also, my lord, searched something, my lord. And
Not
then, my lord,
something, you
I
have to
found-
search in railway documents,
Yes.
not
Yes, my lord.
on other part.
Yes, my lord, so for the viciation, my lord,
I have seen page 53.
my lord. My lord, second, however, during execution of work, variation of quantity against item.
So cause
of
vitiation of contract. Now, what is vitiation of contract as per railway parlance?
work, my lord.
As per railway
My lord,
parlance,
here-
whether any circular, any notification,
Yes,
this is vitiation.
my lord, so.
Variation I have understood.
My lord, so far viciation is concerned, my lord, 6.0, my lord, that is there.
That is clause,
Yes, my lord.
that is clause,
Yes.
but the concept of vitiation.
My lord, so far, we have placed on record by the affidavit, my lord, we have stated that.
What is the legal meaning?
Yes.
My lord,
The legal
difference.
meaning, there are three dictionary meaning I have given, my lord, Black's Law Dictionary, Ramnath Ayer's Advanced Law Lexicon, and Oxford. Oxford says to spoil or reduce the effect of something. Black's Law Dictionary says to impair, to cause, to have no force or effect, to make void or voidable, to invalidate either completely or in part.
Now, they have thrown a concept about vitiation. Now, where is in black and white?
It is not there in the
In,
contract.
in your affidavit, you have tried to explain, I have seen it,
My lord,
and your document also,
yes.
right?
Ah.
But where is the concept of vitiation in black and white in your circular notification? That this much
My lord,
is there, this is the railway board or Ministry of Railway circular. This is vitiation.
my lord, so far the circular is concerned, my lord, page 8 of the affidavit. There we have stated, my lord.
I have seen it, Mr. Das.
And my lord.
I have seen it in the meantime.
The details
Now,
is in page,
question
page
is-
9, my lord.
This is an explanation
Yes,
127.
these are the, my lord.
No, the question is the first one.
Yes. During execution of work, my lord, page 9, my lord.
This is this, I think
Vitiation
everything is
indicates-
in existence. Come to annexure A,
My lord,
reference 1.
yes.
Power of sanction of variation in works contracts where vitiation is also involved is contained in para C V of the railway board's letter and the reference number 1.
My lord,
I think that is the letter
1995. my lord.
1995.
My lord,
If
the
the
same.
concept of vitiation is there along with variation in that document, that is the only one.
Yes,
These are all
understanding. my lord.
next annexure is
My lord,
his-
deliberation, whether
his-
we should give.
his explanation.
Yes,
But his explanation has to have some connection with the concept of vitiation as notified by the railways.
my lord, yes, and my lord, to understand that. my lord,
Already
because-
notified.
Yes,
It has to be in black and white. So this is the concept of vitiation in respect of railway contracts.
my lord, to
Is it
understand-
not?
Correct, my lord.
So
Precisely.
your affidavit is not that.
That is.
Second annexure is the explanation in the case of the petitioner only.
Yes.
But there has to be somewhere the concept of vitiation. This results into not only variation,
The
but
difference of. price
also
between-
into vitiation.
My-
There must be something notified earlier.
my-
You cannot go on saying here vitiation has occurred.
my
One
lord,
X, Y, Z authority will say
That's-
vitiation has
that's-
occurred. No, you cannot say.
my lord, my lord, to answer that query, my lord, again, my lord, page 111, annexure 6, my lord, this is the, my lord, document by which that very viciation, how they calculate, my lord, from that we can, my lord, made out.
Your calculation is all right. But before calculation,
Matlab,
is it not?
That's correct. my lord.
Huh?
But
That-
my lord, but my
That,
understanding is that, my lord,
that distance is 100 kilometer. To understand 100 kilometer, you have to know what is 1 kilometer.
my lord.
So, look, what is viciation? This
Viciation,
dictionary meanings throws nothing,
my lord.
right?
But so
And
far,
Palani.
in case of, my lord, these are my lord rate contract, first of all.
Rate contract is okay, but what is the concept?
Para 13 of the, my lord, affidavit.
As I have already told you, I am not
Yes.
that sharp as that.
Ah.
Viciation, if the concept of viciation is not there,
Yes. But how we do, my lord, may I please?
what vitiates? Basically, it is vitiate. What
Vitiates,
vitiates?
my lord, the price.
Something
between-
has vitiated the
Yes.
entire contractual arrangement. So what are those
Yes, my lord.
which have vitiated?
My lord, this is the price between the L1 contract at
Where
the.
is that?
Yes, my lord, pays 112. my lord. 112, my lord, he also gains by
This is
some.
the
price.
calculation.
No, my lord, this
No,
is the comparison. is there.
do the calculation. To do such calculation,
Yes.
you have to have a
Source.
source. Is it not?
Source is, my lord,
Mr.
6.01.
Mr. Das,
Yes.
we all know that
Yes.
A plus B whole square is
square
A
plus B
something
square plus
something.
2AB.
Right. A square plus 2AB plus B square.
Yes.
There is a formula.
Yes.
Now thereafter you will put A and B. Right? You know the formula,
But.
right? Now you make the calculation 112. To make such calculation, you have to have the formula.
That I can do. My lord,
Am I clear?
yes, yes, absolutely. But my lord, in a general understanding of this,
No, general understanding. I also know general understanding.
In all circumstances, that the rate of L1 must be there in the.
Where is that?
The
You
affidavit-
cannot. If
Yes.
this kind of
Yes.
leverage
Yes.
is to be given to a tendering authority, then they will go on acting at their whims and caprice, at their whims. This has vitiated, this has vitiated. No absolute power, no absolute discretion.
So far, the power is from the, my lord, 6.1 is, that is the.
1 minute.
My lord, last line of the.
Is there
second-
any formula?
Second page, my lord, second page, my lord. Kind of from the second page. This is first page is both variation. And second page is, my lord, last line, vitiation, how they, my lord, do, my lord. Meaning of variation is invalid or legally defective. Railway vitiation is change in interstate contractor due to variation of quantities in the work during the course of execution. The aspect of variation of tender with respect of variation quantities should be checked and avoided. Example, table, my lord. In case of, my lord, 100 quantity, if, my lord, L1 bidder, his price is 2%, my lord, and B contractor is also 1%.
Okay, you apply this formula,
Yes, my lord.
but this is not the genuine source.
To understand. I
Come
was
to a
also-
genuine source where this circular,
Fine.
a particular circular contains this
I
formula.
can get this, my lord,
This is a railway account departmental examination.
to
That will not
understand
do.
myself, my lord, yes.
That will not do. This
Yeah.
is not an authentic source,
Correct.
right?
I will get
If
that.
you have the circular notification of the Ministry of Railways that this is this,
My lord.
then if it is gazetted, then nobody
Sure.
can escape from its application. But
I will get.
there has to be some formula somewhere. You have applied a formula,
My lord.
page 112, but where is the formula? And that formula has to be notified.
Noted.
And that has to be a part of this contract agreement.
At the time.
It depends. It depends. We'll see that.
My lord.
You don't, it cannot, it is not an absolute proposition of law that this is to be. If something is done and notified, situation can be different. It has to be seen. We cannot reach that last mile. If it is gazetted, it is a complete different thing. It binds everybody.
And the railway circular has the force.
But
And,
maybe this, because there is a formula difference between variation and vitiation. And this formula appears to be
applied here.
applied. This page 112. But thing is that somewhere
is
it is to be notified. If it is not notified, then that cannot bind the
Right.
petitioner.
Right.
That cannot be made applicable to the petitioner.
Not so far, our instruction is that.
If it is somewhere, it is, Mr. Das,
Yes, madam.
if it is somewhere inside your file,
I will get.
that, no, that will not bind the petitioner. But if it is publicly notified, then it may bind. Have you got
Yes, ma'am.
my query clear?
Yes, ma'am.
So this will not do.
Correct.
If lordship permit me, in another case, connected case, there's a
First-
definition of viciation. If lordship permit me, I have already.
In the
filed-
first case, madam.
In first case. We had filed our affidavit. In opposition.
Hmm.
By Project Madas. Page 16 here also.
Page
16, and extra 2
of your affidavit.
of my affidavit.
Okay.
29/4/2013.
20,
File on 29/4/2013, at page 16 and extra 2. Issued by the PK Das Deputy Construction, C Construction, Silsot. If lordship permit. So there is a definition, viciation of contract amount.
now deputy chief engineer cannot define.
That's.
Moreover, my lord,
But,
this,
It is the highest decision making authority who has to define what is vitiation. He says about vitiation, but if he has borrowed it from a particular notification or circular, that's okay. I have understood the concept, but concept must be there.
my lord, this.
Page 17 also.
My lord, this communication which net friend is relying, this communication and their affidavit in the other case are the same thing, my lord, because it is a letter in connection with the writ petition pending before this court. WPC.
I have asked,
Yes.
That
firstly, I am saying that it must be in existence, not inside the file. It should be a publicly notified, properly circulated concept. So where is that? Merely now deputy chief engineer is saying this is viciation. That cannot do. It must be in existence prior to execution of the contract. Right? These are all
queries.
after the disputes have arisen. But question is that vitiation, concept of vitiation must be there somewhere prior to execution of the contract, because 6.0 is clear that vitiation is there, concept of vitiation. But that has to be notified.
That's it.
Suppose if he does not understand, a contractor does not understand the concept, even if it is publicly notified and signs the contract, that is a different situation, right? But if there is no concept like vitiation prior to execution of the contract and he signs the contract, that is a different situation.
We have to.
If it is publicly notified, gazetted or something like that, he cannot take the plea that I do not understand, so I have signed now unconscionable contract. That cannot be the plea. We are discussing it, otherwise it is a case of arbitration.
Yes, ma'am.
But still, because of some reason or other, this petition is kept pending. I do not know for 11 years for what reason. It should have been,
latest Supreme Court decision.
question of maintainability should have been decided on the first date or second date itself. Somewhere or for one region, this has been kept pending. Now there are laws also,
Judgment.
decisions also. Tell me the concept, that's all.
Oh, man, sorry.
Nothing is required.
Yes.
Is there any existence of this concept of viciation
We will get.
in railway contracts in a proper manner?
Prior to execution of the contract. Yes.
If it is there in the railway parlance and publicly notified, or circular Ministry of Railways or Railway Board, somewhere it is in existence, that's okay. Otherwise, I think your this explanation at the
Yes.
affidavit is not very convincing.
My lord, in that case, my lord, as per the convenience of the honorable court, my late this matter on Monday, can it be, my lord? In the winter, I will get it, my lord. And so far, Lossi has restrained me, my lord. So far, the my lord, the maintainability is as pointed out by Lossi, but the.
No, question is, you should have also.
Yes, the recent decision of the Honorable Supreme Court 2021 4 SSA 379, my lord. There, my lord, it is very categorical where there is a concluded contract and the contract is having a clause of, my lord, arbitration. In that case, my lord, para 54, in the present case, since both the parties are admitted the existence of arbitration agreement between the parties as recorded the judgment of the High Court as and even before the court during oral submission, parties may either appoint so arbitrator consensually, failing which
Nothing
an
is
application of
mentioned, nothing is mentioned in the orders that Dr. B.N. Gogoi has raised the point of maintainability
Yes.
from 2012 onwards.
And my lord,
My case is different from that point of view. She has already been admitted the final agreement. And she has not submitted the final forest royalty.
Let us see this one also.
My lord,
This, the first one, my lord.
Lordship, in my affidavit, if Lordship permit me, her amount to be,
After going through the petition, one should have raised all these issues, point of maintainability. But nowhere, since 2012, nobody has raised the issue. I have allowed this petition to remain on board. Now at this stage, after 11 years, it is not open for you.
Lordship, in my case.
You have allowed, have you raised the point of maintainability in your affidavit?
We have not.
Then, now you cannot argue. After 11 years, Mr. Das. There are laws to that effect,
My,
decisions to that effect. Now, concept of, that's all,
that's it.
that's all.
But
He is saying that this petition will be dependent upon the decision in the other petition.
in my case, she has already put the signature, your lordship, in a final agreement. Final agreement. Final
Variation.
variation.
Then
Then now question is to release the amount.
vitiation involved.
Yes, in this case.
In your case, the other case,
Yes.
vitiation is involved.
She has deducted, she has signed. Only part is that, your lordship, we cannot release the amount only for 3 reasons. Page 6, your lordship, non-submission of forest realty clearance certificate, non-signing of no claim certificate, and not signing the final bill. Otherwise, we have no issue with this.
But vitiation is there.
Decision is there. But she has agreed in this part, in the paragraph 6, we have mentioned it here.
But she is
9
not
lakhs, something is.
giving no claim.
Only point is that, your lordship, another point is that the forest department has issued.
So come up with what is vitiation.
Yes.
Railway
We
document.
will
or so.
satisfy. We will satisfy. Definitely, we have a contract maker to formulate this. type
Clause
of-
6 is there.
there must be.
There must be something which is related to clause 6, or if it is not there, then if it is to be interpreted as per the engineer in charge or somebody like that, then it is not a clause which can be enforced.
Lots.
Am I clear?
In 94, there is some.
But don't delay it.
Yes.
When? Tuesday?
Tuesday.
First, sir.
Tuesday. Asana. Four is this? Huh?
My lord. It's which day, no, Dada? Mine. Hello, can it
31st.
31st? Yes.
31st. Mr. M. Biswas. Learned counsel for the petitioners. Mr. Dr. B. N. Goyal, Central Government Council,
NF Railway.
Not Standing Council. Standing Council, NF Railway for the respondents in WBC 266/2012 and Mr. B. K. Das, Standing Council. NF Railways for the respondents in WBC 6103/2012. Full stop. Learned Standing Council, NF Railways has have sought time to obtain instruction as regards existence of any circular notification of the Ministry of Railways / Railway Board or any other competent authority on the concept of viciation as the petitioners have preferred the petition raising maintainability, questioning contemplated reduction of sums on the ground that the contracts stood vitiated. Lays the cases on 31.
Deep level.
When did they die? When cases were listed in May, you did not make any mention about that.
And that I can't say, my lord.
Who died?
Petition number 4, my lord. Badal.
Which one? First one.
Yes, my 2693, my lord. And item number 5, my lord, rest number 4, my lord. Petition number 4, Mongol Sundar Tele Paul died, my lord.
Badal Das.
Badal Das has died, my lord.
When?
That today I can't say, my lord.
You can't say. You don't have instructions. What to do? What is the case?
Here, my lord, the railway authority, my lord, has increased the my lord, license fee abruptly, my lord. There's an agreement, my lord. And next time, my lord, yes,
Mr. Das, is it
yes,
not decided? The issue is not decided.
Yes, my lord, it's decided, my lord. Now, my lord, question is that, my lord.
Covered, not covered.
It is covered, my
If it is covered, then what
Yes, my lord.
thing remains?
Yes, my lord.
Let us see.
And moreover, this.
2012, 2013
15.
might have been covered by some
2013.
judgment.
Yes, ma'am. And here, Malad, this term of contract is also over. 2015 last.
Was there any renewal after 2015?
No.
No renewal.
Person to the order of the court.
doesn't permit, madam.
Person to the order of the honorable court. Malad, they are
Order only they are continuing.
Person to the order of the honorable court. SSG committee. 7 to 9.
These are similar.
Yes, only the station is different, my lord. Item number 4, my lord, is regarding Morini station. The only station is different.
But that enhancement of license fee. Court has considered it to be exorbitant. And as per not realistic and unviable. So there all these communications were 6/5/2013. Here is, what are the communications?
Yeah, my lord, 9/3/2012.
Hmm?
9/3/2012, my lord. Page 50. Page 46, my lord.
9. Yes, what do you say?
My lord, so far this matters are concerned, my lord, it appears that the terms are already over, my lord.
Terms are over.
Yes.
But
Now,
still a challenge to that.
90 to
remains.
2012, my lord.
Yes. Is it different from the challenge made in the other petitions covered by the judgment? Is it not?
Yes.
Hmm?
Otherwise, my lord, this, as per the policy 2010, my lord.
No, this has been dealt with.
Dealt with, my lord. Yes, therefore, my lord, it appears to be, my lord,
Hmm?
appears to be covered, my lord.
In para, in my lord, the new court observed the new category policy 2017.
Covered.
Those licenses are different or what?
No, this is, and it's a 1 ml, AML. We got an agreement, my lord. Page 21, my lord.
What are the cases involved there in the other one? Let us see.
On A.
Where is the catering policy? Anywhere part of the record? 2010.
Item number 4, madam.
Page 9, the repetition. The repetition must be there. But the aspect of clause 18 of 110 catering policy has been mentioned on page 9, madam.
Figure to statement to state direction.
Fixation, clause 18, fixation of license.
Onward and adhering to new and policy. Is there any comprehensive affidavit somewhere?
Item number 4.
Item number?
4.
It is filed on 7 and 17.
Item number 4, my lord, I have filed an additional affidavit. On 23/5/2018, the chart is there. This is with regard to the Moriani station.
Who is the policy? That circular, whatever.
Page 22 of the affidavit, madam.
Page?
Page 22 of the affidavit filed by the railway. Item 4.
Item for WBC.
Publication, madam.
It is
1131, my lord.
1131.
1131, 2012.
1131/2012.
Is there in the affidavit.
Affidavit, which page?
Page 22, madam.
Page?
Page 22, relevant person regarding, my lord, fixation of license fee as well as, my lord, yes, my lord, license fee. Lordship has got it.
Page
Page 22 of the affidavit, my lord,
of their affidavit.
of the affidavit.
Page 22.
Filed on 16/3/16. Clause 18, my lord.
What was clause 58D in the other judgment?
But here, my the 58 to be read as clause 2 of the agreement. my lord.
Clause,
Clause 2, well, page 22. 58 it speaks about what.
page 22 of which one?
Of 2693,
Page?
page 22, my lord, of the agreement. my lord. Because the impugn notice, my lord, it says that the revised license fee have been become effective from 1/11/2010. And so for the clause 2 of the agreement, page 22, my lord, it says it's comments from my lord 1/1/20. So it cannot be retrospective, my lord. But I have understood from the document, my lord.
Whether this is applicable directly or not?
My lord,
Huh?
it is applicable, my lord.
Sure, come on, son. Right. Yan কৰিছিলা, মোৰটো কোনো কেনে- মোৰটো ৰিনিউ হৈছিলে নেকি? মোৰটো ইয়াৰ পৰাই আছে।
We had a full policy. Catering policy 2010.
It's not safe, but no, but- Giving the last misleading.
But the relevant portion, my lord, that I have annexed, my lord.
No, head is not, head is missing. The head is missing.
It is.
So what to do with this disease petitioner?
My lord, so as per the, or the other.
But can it be matter taken up on one day?
How much time? Because this is 2012.
Yes, ma'am.
It appears. Perhaps it is covered by the judgment.
Yes, ma'am.
No, it is covered, my lord,
Ah.
because all are against like areas.
Now, he is making a submission that these petitioners have died.
But next Friday, ma'am, if it is possible, ma'am.
File it within, that has to be allowed also. Might have died 5-6 years back. You are ignoring all this. Which petitioner?
But the petition number 4, madam, it is case, madam.
WBC
2690, madam, petition number 4.
2693,
Yes,
Mr. Botakur, S. Botakur. Learned counsel for the petitioners in WBC number 2693 2012 has submitted that during the pendency of the petition command, the original petition number
4, madam.
4 within bracket Badal Das has expired. Anybody else?
In my 2689, madam.
Similarly, comma. He submitted that similarly, comma. In WBC number
2689 or
2012,
Yes, ma'am. He also, madam,
comma, the original petition number
4, madam.
4
Yes, ma'am.
within bracket Mongol Chandra Tilipal
Yes, madam.
expired. In the meantime, full stop. He has sought for a week's time to file appropriate pleadings for substitution. the prayer, Mr. Your part,
MCT, man.
MC,
MCT.
M. Chetia, learned counsel for the petitioners in WBC 1131 2012. And Mr. A. Walcott, he learned standing counsel NF Railways for the respondents in
In 1131, madam, 2012.
WBC 1131, and Mr. B.K. Das, learned standing
other
counsel NF
petitions.
Railways for the respondents in
2689.
Baki duta.
And 269.
Other two
Sure.
are present to stop in view of the above submission. Comma, the prayer being by Mr. Thakur, learned counsel for the petitioners in so and so is allowed. List the cases.
On
Tell
7,
me practically, will you be in a position to file the pleading or not?
on 8, my lord, 8 of September.
Otherwise, wastage of time.
Yes, my lord, 8 of September, my lord.
As the petitions are of the year 2012, comma, an expeditious consideration appears necessary as briefed for Mr. Thakur, learned counsel for the petitioner. Mr. Lays the cases on. When
8, my lord.
it. But file it.
Yes.
This copy be kept. Catering policy you take back.
My lord, I will take, that is one copy, my lord. Item 6.
Yes. Yes.
My lord, this is regarding non-payment of dues under the Employees Provident Funds and Miscellaneous Provisions Act of 1952.
Provident Fund next one. Yes.
My lord, the petitioner number 1 was a hospital under a company, Mayflower Company, which is not functioning. And petitioner number 2 is the managing director of that company. And this petitioner number 1 was come under the purview of the Act of 1952 with effect from 1st of April 2004.
Yes.
In the meantime, in 2003, there was some incident which compelled shutdown of this, complete closure of this establishment.
You have said 11/2004.
1/1/2003.
Incident of 2003.
2003. In 2003, a closure notice was issued to the company. And unfortunately, this has not been annexed in this petition, but I have come up with a copy of that closure notice. It was not annexed.
What notice? Closure.
Closure notice by the health department because of an incident of regarding medical ethics and emergency in the hospital, emergency to save the life of a minor girl. The closure notice was given on 2003. Thereafter, since 2003, a case has been registered against the hospital as well as the managing director of the company under the before the Nunmati police station. And the managing director was arrested after he was released on bail. And that criminal proceeding was concluded in the year 2008. In the meantime, most of the employees, they have left the institution and the number of employees came below 20. Below 20. Now, this premature closure or shutdown of this establishment.
As on that it is running or not?
No, not running, not running. It caused severe financial crisis and employees could not, the employees also left the institution. This was categorically intimated to the respondent authorities. However, on 11th of February 2005, petitioner were allotted a PF code showing that there are 57 employees as on 1/4/2004. Then the petitioner in 2009, after this criminal proceedings are over, the petitioner requested the Assistant Provident Fund Commissioner to waive the Provident Fund dues for the period of 2004 to 2009.
No, when did it close?
According to this notice, from that day, it was not functioning.
It was not functioning, then why this 2005?
Because it was mandatory, because this pro forma of coverage, page 23 was submitted. Page 23. This pro forma was submitted before the Provident Fund authorities.
Yes.
Showing that at present, also as on January 2005, the number of employees were 28. But during this after this period, most of the employees left the job.
I don't think so, then it will come. Once it is there, more than perhaps 20.
Yes, section 1(5) says, even if it comes down, then also it is applicable. But here, in fact, a review application was preferred, that is page 45.
What is the decision?
In fact, my lord, there are two conflicting decisions before that.
I'll come to proceeding first.
Yeah.
Let us read the proceeding, then we'll understand.
Yes.
Page 42. I think that is the order.
Order.
Let us see the.
May I read just?
Page 42 or not?
Page 42.
Yes. Yes.
The order is says that whereas the employer in relation to Mrs. Dean's Hospital number 2, Madhgaria, BG Tiniali Zoo Road, had an establishment which is covered establishment under the Employees Provident Fund and the Employees Provident Fund and Miscellaneous Provident Provisions Act 1952. Herein after referred to the Act, holding code number AS 5614 has failed to remit the Provident Fund, Pension Fund, Deposit Linked Insurance Fund contribution and administrative charges towards the Provident Fund and Deposit Linked Insurance Fund due for the months of 5/2004 onwards. In accordance with the provisions of the Employees Provident Fund and Miscellaneous Provisions Act 1952, Employees Provident Fund Scheme, Employees Deposit Linked Insurance Scheme 1976, and Employees Pension Scheme 1995. And whereas purpose of the determining the dues as inquiry was initiated by notice dated 8/5/2009, directing the establishment to appear before the inquiry authority with all the relevant records and documents to respondent their case. To represent their case, the establishment was initially issued a notice under section 7A on 19/7/2007 and date was fixed on 29/8/2007. And due to non-appearance of the establishment in subsequently adjourned to 27/9/2007. The establishment was again issued notice under section 7A 8/5/2009 on 6/7 2009, Sri Ratneswar Jha and Sri Putul Bhatta, authorized representative of the establishment, appeared with the authority letter and submitted a representation for waiver of PF dues due to financial crisis of the establishment. This request is not acceptable since the establishment has shown no compliance since 5/2004 till date, and proprietor being responsible employer should be responsible towards the statutory liabilities and should have at least made some contribution towards PF and its allied dues. Then the enforcement officers also submitted their inspection report and dues. The details of dues have been given, and the total amount, page 44. The above dues of I'm reading the last paragraph. The above dues of rupees 5 crores, 5
lakh.
5,81,708 rupees dues under section 7A and rupees 2,18,557 parent interest under section 7Q calculated upon the assessment and liable to increase till the actual payment and production of deposit challan totaling to 8 lakhs so and so. Now thereafter, next page, annexure 5. A representation was given, which according to the petitioner is a review under section 7B of this act. That has not been considered. Thereafter, page 47, a shock cause notice was issued to the petitioner number 1. Bank account was attached.
Yes.
Thereafter, once again, with reference to the letter dated 14/9/2009, since they have not acted upon the review, this petitioner has again requested for considering this.
Is there any power of review?
Yes, under section 7B.
Okay.
Thereafter, my lord, that nothing has come up, and page 50, another notice of demand to the defaulter has been served, demanding rupees 7,61,296, page 50. In the meantime, the petitioner has paid PF dues since the month of April 2009 to March 2011. because the waiver was for the period of 2004 to 2009. So from April 2009 to March 2011, the PF dues were
If
paid.
you have closed the, suppose this has faced closure, have you informed, have you taken the plea that everything is closed now? But hospital is closed, its registration is closed. Hospital, but closed down the institute. If
It was informed,
30th May 2013, this closure order has been made, 2003. You have got yourself registered in 2004
yes.
by
Because the
filing a
process-
pro forma.
Uh.
If the hospital itself was
Yes.
closed in May 2003, why you have gone there and filed a pro forma?
It was in process because.
And with 28 employees or whatever,
Yes.
you
It
have
was
made
in
a
process.
statement.
We have intimated on 2009 only, we have also intimated that it was closed down, page 39. Page 39, we have
No,
intimated,
that is an order already passed.
yes,
Which order is proceeding, page 42.
Page
is the
42.
Order passed on which date?
order passed on 6/7/2009.
2009. Then thereafter you have started making this.
Yes, because of the criminal proceedings were pending.
That has no relevance.
That is true, my lord, but the thing is that now.
Then you started making disclosure or this and all. But you have appeared, and what is the plea? Page 42, waiver of PF dues.
Yes,
Your representative appeared,
yes, and we
Right.
sought for waiver for
You-
2004 to 2009.
right? So you appeared and said, please waive off
Yes,
the dues.
because of the fact that my lord, section 1(5) of this act, which says an establishment to which this act which applies shall continue to be governed by this act, notwithstanding that the number of persons employed therein at any time falls below 20.
Hmm.
So they continued with that, but it was not.
Where is the question of, where is the provision for waiver?
There is no as such provision I found in this statute that there is a provision of waiver. But one thing Lordship will see that from the month of April 2009 to March 2011, they have paid the PF dues regularly, whatever demanded by the authorities.
Now, this statement, page 43, May 2004, up to somewhere 2009 perhaps. Right? This statement, the table, it appears that this period starts from May 2004,
Yes,
and they have made calculation.
they have made calculation.
They have made calculation up to say 2000 March, perhaps March or February.
This is
February 2009.
9.
And it was in order July 2009.
Yes.
And you appeared before the authority after issuance of notice dated 8/5/2009, where you made a prayer for waiver. But it was not your case that our employees have
All
reduced.
we made.
It was not a
representation-
case that your number of employees were reduced. The calculation is made on the basis of how many employees.
Yes,
This calculation is made.
This is, my lord, something what they are not coming up with a clear picture. Because in FIR, this, all this prohibitory order was passed after that. And then FIR was lost against the company as well as the.
Oh, FIR is different thing, but here there is a proceeding before a statutory authority. Now, your representative appeared and sought waiver. Now, this statement is made on the basis of some inspection report. Their inspection report,
Their
page
inspection.
43. First line. And this dues position and this calculation is made on the basis of what? How many employees? How many employees? And it is not a case in your review that our employees have reduced.
My lord.
So 2004 to 2009, you made a wrong calculation. It is not your case. Your case is we face closure notice. We are having bank loan,
Yes.
right? And see paragraph 4, page 45. After the court verdict, the hospital is in slow recovery path. So hospital was working.
No, my lord, it was under the private practice of this petitioner number 2.
He made the statement. He is the
Yes,
managing
he's-
director. He is making a statement. Hospital is in slow recovery process. Hospital.
Hospital.
It is not he. It is the hospital.
Hospital, my lord.
So
But
that is not.
The only thing is now
See,
remains.
due to above, we have failed to make a regular pay scale
Yes.
and other beneficiary schemes. Clearing closure of hospital as court verdict was not coming till so and so. But you did not say that these employees were not on your payrolls.
My lord,
That is
There are-
not there.
there
Come
are-
to page 48 also. 2 crore bank loan, 27 lakhs to GE Capital CT scan, market liabilities.
yes.
We have reduced the band strength, see, from 30 to 10.
That is true.
So one person cannot maintain 10 beds. Must be doctors and employees. 30 to 10 bed because of our inability to pay salary in time. So they have reduced the bank. Hospital was working.
There were some other arrangements also that is not been mentioned here, but
What then
it was.
remains?
My lord, the only thing is that, my lord, will come to page 53. That is the only dispute now. The amount which is outstanding.
Page
Page 53
53
is an FIR. Here, the respondent or enforcement officer files an FIR against the petitioners, saying that the share of PF contribution, employees pension scheme and employees deposit linked insurance scheme amounting to rupees 3,97,526. Sri Dr. Tarodikanta Sharma, MD, failed to pay the statutory dues to the authority. It was filed on 13th of January 2011. So according to the respondent authorities, PF authorities, the outstanding amount was 3,97,526. Thereafter, Lordship will please come to page 57. We had to pay some amount after that. This is by the recovery officer. This is addressed to the petitioner number 2. With reference to the subject above, it is observed that an amount of rupees 6,14,527 is yet to be remitted for the period from 0504 to 209 against the RC A08.
Let us see the first order, the first order. How
Yes.
much amount is that?
It was 5,81,708.
5,81,000 plus penal interest. 2
Penal, it
lakh.
comes to 8 lakh,
Total is 8 lakh to
2,265.
265.
Thereafter, we made payments. Some
Then come to page 51. That was in July 2009. Now this is page 51.
This is the prohibitory order.
Whereas the explanation so and so. They failed to area dues. At that point of time, 7,61,000.
7,61,000.
Cost of recovery, so and so. So this is the amount.
Yes,
First, it was on to 6/9/2010.
8/9/2010.
6/9. Page 52. The sign.
Sign is 6/9.
That was by recovery officer.
By recovery officer.
Hmm.
Then thereafter,
Then who filed this enforcement officer?
enforcement officer, he files an FIR saying that amount of 3,97,526. Then we made some payment, admittedly, page 57.
No, are you now going into the figures or what?
That is only the figures, because we are going to pay.
That we do not know.
Yes, because these representations, page 58 and 59, even in the affidavit also, they have not cleared this.
These two, page 57 is clear, 6,14,527.
This is of 3/7/2012.
12 later on.
Later
You made
on.
payments. You made payments in the meantime. That is what you have said.
Then why in the FIR it was lesser amount? In the FIR,
That somebody, whether he is enforcement officer, whether he is the person to calculate.
my lord, that is
Are you in the figure or in the process?
my lord, I am on the figure, because in the meantime, they have to, we have asked, you give us the details what payment is outstanding to you. You give us the figure. And they have not given, even in the affidavit, they have not stated how much amount is to be paid. And as per the order.
Where you have pleaded so?
My lord.
What happened to your review? What is your statement?
Nothing.
Hmm?
This says this is beyond 45 days. And it
Where is
was
that?
in their affidavit. And it was not submitted in Form 9 under section 17.
Maybe rightly in Form 9.
Hmm.
Form 9.
Form 9.
It is as per statute.
As per the statute, it was.
So it was not in proper form.
Not proper form.
Not proper form, then review is not entered in.
That was not entertained. But despite that, we have been made.
There was a provision for appeal also.
That's right.
That you did not
We are paying.
prefer.
We are paying.
That you did not prefer appeal,
No,
I think,
no,
against the order of the
not that. That was.
officer.
But the only thing we are on, that what amount we should pay, that has to be clear, that has to be stated by the authorities. The 3% states 3 figures. In on 8/9/2010, on this 21st of July 2009, it was 8 lakhs. On 31st of 13th January.
Now, in the affidavit, they have clarified or not?
No,
That what is the figure?
no.
They are claiming.
That's the only thing. They have not clarified. I have asked, we have asked by this to last. representations.
Clarified,
My lord.
paragraph 5. Clear. Read paragraph 5. It is further stated that FIR under section is for non-deposit of employee share of PF contribution amounting to rupees 3,97,526. The amount of so and so mentioned in a notice dated is for employees and employer share of PF contribution, also interest payable under 7Q. That's all clarified. But no.
But if we go.
Now we go by the
FIR,
statement.
Go by the FIR. The lordship take up the FIR, it clearly says, and I just read all these things.
Now they have clarified. This paragraph 5, they have clarified. This is the position.
Let them give us.
6,14,000. What more? How this writ petition to be decided now? What are you have challenged? 7A order. You have not filed any appeal. Prohibitory order. That is following the procedure.
Madam.
Everything appears to be in, as per procedure. And you are
I am asking for. Give me a
you are
statement.
also clear as 6,14,000. Now, number of employees, reduction of number of employees
Madam.
as per 1.5.
That is, we cannot.
And secondly, from your own statements in the review application,
Madam.
hospital is working, we have reduced the so and so, but you have not said about anything that this figure is completely wrong. Because I have seen this table I have seen, come to page 43.
43.
May 2004, wages, first one,
Yes.
52,757. It appears to be quite reasonable.
Madam.
Total wages for all the employees in the hospital appears to be quite reasonable.
Correct.
I have seen it.
Correct, madam.
And calculation is made on that basis. Now come to your performer. How much you have said declared? 28.
28.
For 28 employees, 52,767 is quite reasonable.
Madam.
I saw it. Had it been an exorbitant 5 lakh, that would have been a different thing. But this appears to be quite reasonable, this figure.
But why these variations in all this?
Variation now, they have clarified paragraph 5.
But the FIR doesn't speak about
We
that.
go by paragraph 5. Now, what is the
FIR. page
FIR.
50 and- sorry, my lord, FIR page 53.
PS 53? Now, who lodged the FIR?
Enforcement officer, EPFO, any region. It takes care of all these things. Employee share, employer share of PF contribution, employees pension scheme, and employees deposit linked insurance scheme amounting to rupees.
I understand, so and so have verified the revision or report relating to Provident party. The management will statutory contribution on the student and conference of course.
Here it is employer's share, and in paragraph 5, employee share.
Only payable by the by under so and so towards employer share of PF contribution. So and so amounting to so and so. No, you read it.
Madam.
Read it, read again. See the fill up part, May 2004
May
to
2004.
February 2009.
9,
Towards employers' share.
share.
Now read, though the said contribution, meaning thereby employer share, were duly payable by the employer under section so and so, so and so, and so and so of the Act, towards the employer share of PF contribution, employees' provident pension scheme, and employees' deposit linked insurance scheme amounting to rupees so and so, Sri so and so failed to pay the said statutory dues to the authority of the so and so. So it was employer share. Clear cut.
Employer's share.
Clear cut. Now come to this paragraph 5.
Yes, madam.
Paragraph 5. Same thing.
Now for non-deposit of employee share.
Employee share, it will be employer given by employer.
employee share of PF contributions to 3,97,000. Here it is employer's share.
These are,
My lord,
either there are two kinds of
I can
contribution.
understand.
Two kinds of contribution. One is to be given by the employer.
Employer and-
The other is to be deducted from the wages of the employees.
Employees.
And these, either of this, but it is clear that he has mentioned one part. Out of those two parts, this enforcement officer has mentioned about one part.
But by the letter.
It is towards employer's share.
I can understand. There may be some typographical or.
Maybe some, but it is not that this figure is completely out of the blue.
But my lord, what
This
about
is clear.
page 57?
But
That-
57.
57, again, it was, amount was 6,14,000. What is the basis? Am I not
No.
entitled?
You may go for explanation there for that,
That-
but
that's
why
what-
read?
That,
For that.
that's why I have sought
It
for.
is observed an amount is yet to be remitted for the period. You have made contribution in the meantime. Is it not? Come to page 56. You have deposited something.
So I have deposited. I
You have deposited something.
I have
So
deposited.
ultimately, what has happened? Come to page 44 again. It was 8 lakh.
Yes,
It was 8 lakh. Right.
my lord.
Then come to page 41, it was 8 lakh. Then you made some contribution perhaps. Come to page 50. 7,61,296. It has got reduced. Page 50.
My lord.
Right. Then page 51 also, 7,61,296. You have made some contribution.
Hmm.
So it has come down to how much? Let us see the figure. 35,000, 35,000, 30,000 means by 1 lakh.
1 lakh.
1 lakh. Now deduct at least 1 lakh from this figure, 7,61,000. How much? 6,61,000.
61.
Now, what is the claim? 614.
6 lakh.
It is your to your benefit. 6 lakh.
My lord,
you-
at least I am entitled to know from them the dues which are. I have deposited 50% of this
But
amount.
whether for that, setting aside of all this is sustainable.
My lord, that's true, but I have already.
Setting aside of this, I can give you that liberty, or they may be directed to make a proper, furnish a proper statement.
That's true.
But whether we are not going into nitty-gritties of the figure, but appears to be reasonable.
But
And paragraph 5 also says whatever you have said, it appears to be reasonable. Paragraph 5 explanation.
6 lakhs 14,000.
That is what they are saying in the affidavit. So you want the proper calculation,
Yes, ma'am.
then it will be, statement will be given to you.
Well,
But that will not,
my lord, I concede to that.
that
but
will not make you succeed in this
I
repetition.
concede to that, and out of this 6 lakh 14,000, we have deposited 50%.
Whatever you have deposited will be definitely given benefit.
As per the court's order, and they give us a statement, giving us an opportunity.
Yes. Only remain.
Well, Lord, in fact, your lordship has rightly said, under section 7I, there is a provision of appeal. They did not file an appeal because the appellate provision says he must first deposit 75% of the dues. That perhaps to avoid that approves this court. And my lord, the 7A proceedings is a proceeding for determination of the dues. So it was determined in their presence, and 7A proceedings is a civil proceedings, my lord. So all the civil power are there, summoning and everything. So it is a detailed proceeding under the statute. So they have appeared there and the determination was made. And after that, they said they filed a review, but it is not as the lordship will find on the top appeal. The RPFC has no power. to
Whatever, it is not in proper form.
appeal. No, and the review also, my lord, then my lord, they cannot file. There are two types.
I think appellate authority is the best authority to
That's
determine all the factual disputes.
My lord, that's said
We
so.
are into certiorari jurisdiction. That scope is limited. Unless
I
that
agree. Okay.
authority has exceeded its jurisdiction, all those things are there. So those factors are not present here in
Question
the
of
writ
fact will
petition.
not that.
So if
The only thing is that we should know what the outstanding dues.
that can be given,
And that
The dues payable by them, if they want, well, we can.
the proper calculation and
Dues
dues
payable.
deposited by them in the meantime
Hmm.
against this,
And they'll make. the-
against the order of 8 lakh something. First order is of 8 lakh something. Whatever they have deposited in this period, everything should be given to them
Them,
by way of a statement.
but as on today, every dues will be.
No, we are deciding only this
No, that's
definition. We are not going into that.
till 2009.
Whatever payment the petitioner have made in respect of the claim determined by the first order, 8 lakh something. That statement, up to date statement will be given. That's all.
And based on that, he will make payment.
Otherwise, you have some other
Proceed.
procedure for enforcing the,
It is for. his
enforcing
benefit.
it.
It is for his.
I am not,
benefit.
we are trying to find out whether this petition succeeds or not succeeds.
Malay.
If does not succeed, only I am giving a parting
Oh,
direction
No,
that this.
any, like.
Other provisions of the act will take its own course.
No. No, sir.
And the last.
You
part
have,
is-
you have enough
No,
wherewithal to
Definitely,
proceed against them.
definitely.
So we are not commenting on it.
We are duty bound to proceed now.
You
There is
proceed.
statutory.
You proceed whatever way,
Hmm.
we are trying to find out whether this petition can be
No,
granted relief or not. But I don't find
no.
neither review nor appeal
No.
and determination of factual part is the within the ambit of the appellate authority, right? So that is we are,
Perhaps my senior is correct because of that deposit of 70%. The petitioner has
and there is waiver also.
The waiver authority is central board.
central.
Central board.
Okay, we'll come back and,
My lord, at two, I have been part of.
okay, we'll dictate. If you have some other business, okay, but we'll dictate Mr.
No,
Chakraborty.
no.
Okay, we'll sit 15 minutes late.
That the writ petition would be infractuous. But for an intervention, my lord, if I'm able to make out a case. Page 86 for a moment.
Six.
I'll narrate the facts from there.
Okay.
May I read it? This is a communication from the District Fishery Development Officer Tinsukia,
86.
86.
Okay.
There's a communication from the District Fishery Development Officer Tinsukia to the Joint Secretary to the Government of Assam Fishery Department Dispute dated 30th of May 2023. What does it say? Subject. Regarding sale of fish by lessee of Brahmaputra Part 1 and Dibang Nadi Fishery and Dibru Part 1 Fishery in Tinsukia District. There are two fisheries now. Brahmaputra Part 1 and Dibang River Fishery. This is one fishery. And Dibru Part 1 Fishery in Tinsukia District. Mary. Sir, with reference on the subject cited above, I have the honor to inform you that a permission granted earlier by order number so-and-so dated 21/12/2021 for passage to sale point of fish in Dhola Bazar, Dighal Torong Ghat, Hilika Ghat, Guizan Ghat, and Dinjan through vendors with passage through Maguri Metapung wetland is hereby withdrawn with immediate effect until further instruction.
You are
We are none.
Rongago.
We are not. My lord,
Are you a lessee of these two
No, no.
fisheries?
a particular fishery cooperative society was the lessee of these two fisheries. So far as Brahmaputra Part 1 and Dibang Nadi fishery is concerned, it was a regular settlement. It was enjoying a regular lease. And the same society was enjoying Dibru Part 1 fishery on daily basis. Now, this enjoyment of daily basis was challenged in the writ petition by another society. And the order of the Honorable High Court starts at page 70, operative 75. It's a consent order.
Page
70. The daily basis settlement was under challenge by another society. And the order of the Honorable High Court is at page 70. The operative part is 75. It's a consent order. I was not a party there. That is not the issue, but it's a consent order.
yes.
Paragraph 3 and 5 are relevant. Mary. The petitioner's counsel submits that a private respondent has been allowed to operate the said fishery on daily basis since 3/1/2022.
Which one is the private respondent name?
My lord.
Is
Private
the name of the
respondent
society?
society. Dibru Dangori.
Society name?
My lord. I'll just get the name. Dibru Dangori River Part 1 Means by Samiti.
Dibru
Dangori.
Part 1.
Dibru Dangori River Part 1 Means by Samiti.
Yes.
He submits that the same being in violation of Rule 12 of the Assam Fishery Rules 1953, the state respondent should be directed to issue NIT for regular settlement of the fishery. Paragraph 5. In view of the
Fishery is Dibru Part 1.
Dibru Part 1 fishery, that one. Lordship may kindly take note of the date of the order, 15/5/2023. It is prior to that 30 May 2023, 15 days earlier. Page 86, communication is 30th of May. It is prior to that. In view of the consent of the parties, the state respondents are directed to make regular settlement of the fishery within 1 month from today and complete the entire settlement process by issuing an NIT and selecting the successful tenderer within a further period of 1 month. It is made clear that the present arrangement of running the fishery shall continue only till 15/7/2023. Therefore, the society which was the lessee on daily basis could operate until 15/7/2023. However, since the date of the order is 15/5/2023 and it was holding till 15/7/2023, the communication dated 30 May 2023 came in the way of selling the fish in the ghats. Am I clear, how it affected? Now, this led to filing of a writ petition, that is WPC 3699 of 2023, the order at page 87, how it was disposed of. They were aggrieved because if I cannot sell my fish in the ghats, how do I operate the fishery? Both the fisheries, in fact. 87. The operative part is at page 93. The Honorable Single Judge took note of all the other orders also that it has to be settled within 1 month. 15/7 is the outer date. Everything was noticed. And this order was passed. It is 28th of June, 28/6/2023. Paragraph 13, may I read, Miller? Nonetheless, as the petitioner has demonstrated that the petitioner society has fishing rights over the 2 fisheries named here before, those 2 fisheries, Miller, it is natural that the petitioner would also have a right to take his product to the market. Therefore, till such time the petitioner society has a right to operate the 2 fisheries referred above, the Deputy Commissioner Tinsukia, in consultation with the DFO Tinsukia Wildlife Division, shall earmark a road by which the petitioner society can take the yield of the state fishing to the market, and a decision to that effect shall be taken within 10 days from the receipt of the certified copy of the order or 12/7/2023, whichever is earlier. My lord, by the earlier order, the Honorable Court said by 15/7/03, you complete the process. And by 28/6/03 order, 2023 order, the Honorable Court said earmark a road in respect of both the fisheries. Otherwise, Maguri Metapang bill is coming through midway. You have to, it should be a road. Now it's a land, my lord, not a waterway. It's a land. Accordingly, without earmarking the road, a tender notice at page 95 was issued in respect of Dibnodi fishery. The other one is a regular settlement, it's continuing. Without earmarking a road at 20/07/2023, on that date, a notice was issued for settlement of this fishery. The last date and time is
Page
95.
vernacular is 97.
97.
Hmm.
May I read the vernacular in English one minute?
Okay, you read the English, I
Fine.
see the vernacular.
No, it's okay, madam. মাননীয় গুৱাহাটী উচ্চ ন্যায়ালয় গুৱাহাটী লেক আবেদন আদেশ মতে আৰু অসম চৰকাৰৰ মীন বিভাগৰ যুটীয়া সচিব মহোদয় 19/7/2023 তাৰিখৰ ইংৰাজী চিঠি হুকুম মতে ইয়াৰ দ্বাৰা সৰ্বসাধাৰণ ৰাইজৰ জ্ঞাতাৰ্থে জনোৱা হ'ল যে তিনিচুকীয়া জিলাৰ অন্তৰ্গত নিম্নোক্ত মীনমহলসমূহ বিপৰীতে উল্লেখ কৰা সময়ৰ বাবে নিবিদা যোগে নিলামৰ কাৰণে জিলা উপায়ুক্ত কাৰ্যালয়ত অহা ইংৰাজী 21/7/2023 তাৰিখে পুৱা 9:30 বজাৰ পৰা ইংৰাজী
Okay.
22 This date of last date of submission is 22nd, is coming 22nd 8, and the time is as given 2 p.m. We did not challenge the tender notice per se. We say without giving the road, which is also a direction of this honorable court, how could we issue a tender notice? Therefore, all we prayed was 22/8/2023, we push back a little so that the notification comes and we can all be adjusted. Because when I submit my bid, I would calculate my expenses to be done. How do I carry my boat through the road? Which is the route? What total cost factors are there? Therefore, kindly let the tender notice be there. Just the closing date, you push it to that extent so that in the meantime, we get the road, the notification. That was our case in the writ petition, my lord.
That is notified already.
I'm coming to that. my lord. After filing of the writ petition, a notification has been issued 3/8/2023. I sought for adjournment to bring it on record by way of additional affidavit. Now, this notification is in respect of reaching the same very ghats, but from Brahmaputra Part 1 and Dibang River fishery. Both the fisheries are separated by a stretch around 30 to 40 kilometers odd. To reach, it's not a waterway, this is a road. Now, how I address your lordship on that? Notification, may I read at page 112 of my additional affidavit. I'm still not challenging the tender, my lord. I'm trying to persuade my lord that they have given a road, but for one fishery. Kindly give a road for the one which we have issued the tender. May I read 112 below of my additional affidavit?
One.
I'm not against anyone. Even I would also participate in the same tender process. The difficulty I foresee, they would also foresee tomorrow.
Now come to page 93.
93. My
This paragraph 93
lord.
is in respect of that particular society
My lord.
who had rights.
Correct.
over the two fisheries, one daily basis, the other is regular basis.
Correct.
Till
Absolutely.
such time that one road be earmarked so that they can
Sale.
take the fish to
15-7, one goes off.
the
Sale
sale
points.
points.
Sale points.
Till such time, and secondly, para 15,
My lord.
that everything extinguishes on 15/7/2002.
Correct, my lord. True.
So nothing
Correct.
is,
Absolutely.
nothing is directed as regards
True.
any road from Dibru fishery to any sale points.
What I am on, my lord, is the difficulty faced by the one who was in possession.
That is there.
No, I'm not on them, not on them then. Now,
Daily basis stopped
No,
on
daily basis stop.
15/7.
my lord, may I rephrase my submission? Here are two fisheries. In respect of one, it is continuing and the notification has been granted given the road. The other one was a daily basis operation. Lordship may pass an order, but I'm submitting, was on daily basis, which stopped on 15/7. The problem
15/7.
did not stop.
And this order, page 93,
No, the problem
was to facilitate the
Lessee.
that lessee that
My
who
lordship.
was running on daily basis to
Correct.
facilitate
Him to take
their
the sale point.
reaching the sale points
True.
only till they
Absolutely.
operate.
What I am on, my lord, is the problem was never over. If the lessee had a genuine problem, which the honorable court took note of because of the Maguri Matapam bill and directed given of a road, after tender, whoever comes in there, the same thing, the riverway will not
For
be
that
done.
tender process is not going to be.
Well, I'm not praying for tenders.
unsettled.
The last date may be extended.
No.
My submission is so far as
This notification is what, how it is distinguished, how it is
I'm
creating hurdle.
page 1. It's not creating hurdle. Rather, it has clarified that it is only in respect of the other fishery, not in respect of this. Page 112 for a moment, you know. The problem of Maguri Motapung is still there. For one, they have given the road, the land route. For the other, there cannot be waterway. There has to be a land route, you know. They're 30-40 kilometers away. Everyone will have the problem tomorrow. We are not on that. Tomorrow, when I submit my bid on 22nd, I must calculate the expenses I have to meet, you know, because the route is not given.
You calculate the expense and file your bid.
There is no road given, you know. I am on that. The waterway is blocked. Waterway is not permitted.
Let you become successful, then you do it.
What I am submitting, you know, the entire tender process, only a road needs to be indicated. It's a matter of a day. They can do it tomorrow also. It's a matter of a day.
This is completely misconceived.
My lord,
Privacy.
may I invite my lord's attention to page 112 of the additional affidavit? I leave it to your lordship. At least I pointed out.
Litigation for in respect of this fisheries litigation has become a.
But I'm not against it. What we are praying, kindly earmark a road because the water is blocked. 112. In person.
Go there and ask before the deputy commissioner and fishery department.
No, we have come to your lordship, you know, only saying the last date closure may be put, if it,
You have filed this case when?
we filed this case long back.
Then there was enough time
No,
for you to make
that observation may
representation.
do.
Did you approach?
Deputy
Did
commissioner.
you approach? Yes. Deputy
No,
commissioner,
at that point of time, there was no
please
road.
identify a road.
At that time, there was no road. We came to the court only saying that we are not even challenging the tender. 22nd it stops, let it be 25th. That's what we say. Please indicate a road. The same thing can be done on the other part of the river, 40 kilometers away. We say 3 days, kindly indicate, give us that notification. We'll also participate correctly. This will give rise to a different legal problem for everyone. That difficulty, which I'm submitting, Milord, is genuine for any fishery society because the waterway is blocked. Officially, it is blocked. The DFO has a standing thing, Milord, page 27
What kind of projection you have made in this additional affidavit?
in additional affidavit. In substance, we say that this notification is in respect of Brahmaputra Part 1 and Dibang River Fishery, which is around 40 kilometers away by land. This is how we say so, page 112, if I may demonstrate, Milord. Dhola Bazar sale point, the initial point is earmarked at Dr. Bhupen Hazarika.
There you go.
No, I'm on the notification itself. I'll read, go to the pleadings. Page 112.
Yes.
This came after filing of the writ petition, my lord. First one,
Yes.
Dhola Bazar sale point. The initial point is earmarked below Dr. Bhupen Hazarika Hetu on the bank of the river. Next one also Dighal Torong Bazar sale point. The initial point is earmarked below Bhupen Hazarika Hetu. Every sale point, my lord, the starting point is from that fishery. We are 40 kilometers away. Now, this fishery, when it is going to be settled, always say, kindly give us a similar route so that we can participate. Delay by 3 days, 4 days, or 2 days. Issue a notification in respect of the road from this end also. That's what we say. The sale points, 2 would be within the fisheries, 3 would be in the arc, spread out.
This notification is of 3rd August.
3rd August after filing.
We
Therefore,
are on 17th or 18th August.
they have not issued for the other one. I am not challenging this. I have no reason to challenge this. This is a road given as per High Court's order in respect of Brahmaputra Part 1 and Dibang River fishery. What I am on, 2 days they can wait, they can issue a notification in respect of deep.
Why 2 days is so sacrosanct?
My lordship, all we need is a road. I am not praying for a stay order. What we say, tender is perfectly valid. It is in compliance of the Honorable Court's order. What we are submitting is that, my lord, we need to participate with a correct assumption of bids, my lord. And we need a road because the Honorable High Court has said so.
No, this has page 75.
Page 70.
This order has attained finality.
This order has attained finality. This is 15/7/2023. You settle. 15/7 is gone.
15/7. 15/7.
15/7 is gone.
Gone.
I am not saying do not settle. You have to settle. And it will be contempt otherwise if I say a wrong thing. If they do not settle, it's a contempt. There must be a tender. And with 28/6/2023 order, there must be a road. What I'm saying, the waterway is blocked. Kindly give a road for this end also. A notification brings it anytime they can bring it on record. It's a similar exercise to be done. Nothing so difficult, my lord. And if I may invite my lord's attention to page 77. After High Court's order, what the DFO has stated, page 77. This is the difficulty. The waterway is blocked. They might have their logistics, how they calculate the bid. We found it difficult.
No, after issuance of tender notice, have you made any representation?
No, we have
regarding
not.
this?
We have approached this court. But I am only praying, let them issue a notification. 2 days they may take a time and issue a notification. 22nd be 25th. That's all. At least we come to know, my lord. Those page 77 for a moment, my lord. Page 77. I leave it to your lordship. I just pointed out what the zone of difficulty would be tomorrow.
You should have represented it before the deputy commissioner.
Or my lord, let the tender be there without issuance of any road. Again, that bids will differ, my lord. The calculation of bids would differ. It would not be win-win all the way. Suppose I would bid 10 lakhs or 7 lakhs. And in this situation, I may have to bid little bit less or little
We
bit
are
more.
not in the speculative.
I am not on the pitch.
Mr. Boni,
I am not on the beach
we
anymore.
are not on speculation.
I am not on the
That
pitch anymore.
because of road, it's.
I am not on, but
Bid will
but
result
com-
in lesser
in com-
figures.
correct, my lord.
We are not in the.
I leave it. I come to limb B of
Nothing
my
depends on
I take a
speculation.
second limb of the argument when the honorable court, assessing the situation, had directed.
We can only issue notice.
My
That
lordship,
is in something in a letter that the successful bidder faces any problem regarding road to the sale points, we'll consider it.
that observation be there, my lord.
No, we'll not.
Then
we'll
page
only issue
77 for a
notice.
moment,
Absolutely
where the
no case
difficulty
made out.
lies. Page 77 for a moment, my lord, where the difficulty lies. Page 77, after High Court's order, this is the order issue. Page 77, this is 23rd of May. I'm not paying for a stay, not at all.
This is already stayed, my lord.
This,
Stayed.
no,
Stayed. This
What I am-
letter is annexed, my lord.
my lord, let me complete my submission, what I am on. This is the ground level
No,
difficulty.
you have not said that this is stayed, which page?
My lord, I'll coming, my lord.
But he is not even allowing me to complete my narration of it.
No, I'll go to the
Absolutely.
page only, not for making any submission. Which page?
My lord, I'm seeing, my lord. Page 87 onwards. now. To debrief and wait to know.
Page square.
Page 92, paragraph 12, he's referring to, my lord.
Okay, so it petition there now.
And page 91, paragraph 10.
In IM, my lord, it is annexed, my lord, page 24. WBC 3457. Three, 4, 5, 7. It was the next K. 79. 79. This paper was realized. Last bill. Stay this one. There are 1083. Page 83, para 10.
Page paragraph 10.
10.
Page 83.
Quoted.
Absolutely, my lord.
That is
Thereafter,
gone.
paragraph 13, no, thereafter, paragraph
State
13.
operation.
Thereafter, paragraph 13. That's what I am on, my lord. The DFO's stand was stayed because he did not file any application for when the matter was going on. That attended finality. Thereafter, paragraph 13, page 93. Yearmark Road. In one, the settlement is continuing. The one is over by 15/7. All I am praying, issue a notification giving the route, the land road. The waterway is not open, my lord. His observations are stayed.
No, Mr. Boni,
My lord.
if you both the fisheries are separated by a stretch of 40 kilometers,
My lord. Land.
we do not know what is the position. That was not an issue that other fishery.
Page 13, paragraph 13. Paragraph 13. The waterway was never opened. The DFO acted unilaterally, jumping over the High Court's order.
This
That's what it was
particular
stayed.
paragraph 30,
13, my lord.
see,
Actually, what I'm praying is for all.
no,
They do not
no,
see it,
you
what
are-
I foresee, my lord.
I'm not.
Only a road has
getting
to
the
be given.
point actually.
My
Not
lord.
getting the point. Firstly,
First.
there were two fisheries, that is what you said,
86,
somewhere,
page 86, my lord.
page 86.
Brahmaputra Part 1 and Dibang River fishing. And Diblu
One
Part
is
of-
Brahmaputra Part 1 and Dibang Nodi fishery,
Right.
that is in regular settlement.
My lord.
One is Dibru Part 1 fishery, Tinsukia district,
Let's-
right,
daily basis.
which was on daily basis. Then this writ petition was filed and order 15/5/2023 was passed. That all said and done till 15/7/2023. You
Finish it.
finish it. And then came the issue raised by that society who was in holding that
My lord.
lessee right daily basis. They came with a writ
The sale
petition.
right,
Say
sale point
that
rights will-
point
My lord.
be earmarked.
The reason.
Then they got satisfied. They never challenged this order
But
because
because
by the
sir,
time it has come to an end.
Only
It has
to
come
give
to
a
an
road,
end. It has come to an end.
my lord.
15/7,
Yes, yes.
They're
come
over.
Come over,
they're over. Now, this Dibru,
my lord.
Dibru Part 1 fishery. Now that is proposed to be settled.
Yes, it should be.
That
also.
is proposed to be settled.
Should be settled also.
Hmm.
Should be settled.
Now you are coming up with a plea that there is no road for
As
setting
per
the piece.
the direction of this
From the-
honorable court. As per direction of this honorable
No
court.
direction. That direction was limited to
Somebody else.
that society, daily right.
If
You
lordship takes up that plea,
that
the problem does not vaporize, my lord. The Maguri
you make
matter,
applications before that. The deputy commissioner.
the
they
last
will
day would
work out.
the
If
last,
government, because of not working out the route,
that is the
let them
direction. of-
suffer. Government, let them suffer.
What I am on, if lordship.
That because of that will result in lesser bid.
86 and 93. if
It
I
is only for the successful bidder to
Correct. But 86 and
after
93.
entering into the picture
Well,
as
for
a
moment,
lessee,
If I,
they will face difficulties.
for a moment, if I, with permission, my lord,
And
86
all these are in the realm of speculation.
it's not a speculation.
Whether you are going to bid or not, that is also not sure.
86 to 93, my lord.
Get or not, that is also.
Whether you will be a participant bidder or not,
So
that
far
is
as
not sure.
86 and 93 is concerned.
No, you are not a bidder even as on date.
Actually, he should have supported me. The problem would be for all.
No,
The problem he would, the one is enjoying investment.
This is all to prolong the
No,
process.
Not at all. Only 2 days, they should have notification, my lord, that's all. No, I will not have a choice. It's coordinated by judgment saying 15 seconds.
One participant, one intending participant bidder speculating something that after settlement, they will not have any road.
There is
to-
no road
It
at
is
the
for the
moment.
settling authority to decide.
My lordship, there is no
And
road
if you,
to take to the settle point.
everything will, some right will come only if you become successful bidder. But before
That's a view.
successful
one-
bidder, you have to be a participant
My
bidder.
submission may be recorded, my lord, that before giving the road, the roadways as directed by this honorable court, the tender was
No,
quoted.
no, no.
We are not
This is
paying for a
not the
stay.
case.
2 days be delayed, they may issue. Otherwise, this writ petition may come
You
into. void.
calculate your own bid, own amount, participate there. That direction was only for that particular lessee up to 15.7 earmark a road.
That is how the government proceeded. Since they are not there, we will not give a road. That's
Now
all.
this has become permanent.
This is for
This is
Brahmaputra
permanent.
part 1 and
Now,
Vivang
if
fishery.
the successful bidder faces any problem,
They cannot
in
take that
future,
road, my lord. The
in
fisheries are
future,
a part. The
you
fisheries
are not a
are way
successful
apart.
bidder. Mr.
Any
Modi.
person, my lord.
To be
If
honest,
he
my lord,
faces with this situation, he will come up with.
to be honest, my lord, Dibru part 1, I am the immediate neighbor. I don't need any road if I get settled. Question doesn't arise. He belonging to other, he's not even neighbor, my lord. How come, my lord, what is his locus?
That is permanent.
Forever.
That is for a different point. What I'm trying to say, my lord.
Right.
Like
You are
our Soraikat
saying-
bridge is there,
you
my
are
lord, 40
saying-
kilometers down a person
You
from
are
that fishery
saying
does
that.
not have an access from that point. The land road is from that, the Brahmaputra bridge or the Horaikat bridge, my lord, 40 kilometers down. If I go downstream, we cannot have a
We
same
can
road.
only issue notice, then deputy commissioner will come up with the statement whether actually there will be a road
Would-
or there is
would
an
my lordship-
existence of
My
road.
lord, would my lord,
All these are disputed now.
lordship, would my lord be pleased to post this matter for motion on 22nd?
No, we are issuing notice returning within 6 weeks.
Then it becomes infectious. I mean, my lord.
No point. I have not found out any privacy case.
All right, I take it that way. I would not even argue based on
Afterwards,
that.
I'll say one thing,
But
my lord.
tomorrow, what I'm thinking of, this issue may crop up, my lord. And will crop,
Crop up,
will crop up, my lord.
crop up. It will be cropped up by the successful bidder. This issue can be raised by the successful bidder.
That also.
All that, no,
Yeah.
I'm not going to do it. We cannot preempt everything.
I-
We are not forecasting, mister.
My lord,
Then I leave it, my lordship. I
I
leave it.
cannot forecast everything. Just because you are expecting that you will be settled, then you will face with.
I am not even
Certain-
expecting I'll be settled to
We do
participate.
not know whether you
following-
participate or not.
Following the orders of the honorable court, there ought to have been a declaration of a road by a notification
No,
prior to
that is-
issuance of the tender.
that order is limited to 15.7, up to 15.7.
That understanding, actually, the government also.
Allow and earmark some road. Now, instead of that going ahead, they have permanently earmarked.
For a different fishery. The sale point is
That we'll
40
see,
kilometers away.
we'll see. This is your 40 kilometer distance. There are several routes. These sale points are quite impractical for you. If it is separated by a stretch of 40 kilometers,
Sale,
these sale points would be quite impractical for you.
perhaps I could not place myself properly. The area of operation, the fishery boundaries are 40 kilometers away, around 40 kilometers in between stretch of land. And the sale point in the form of an R. It can.
No, this problem, Mr.
sale point is
Modi,
a fishery specific.
would arise only if the successful bidder faces any problem in selling their fishes.
I leave it to you.
We are in the
I
field
will-
of speculation now.
What I was on, issue the notification, then come with the tender or the closing date. That's all.
And Lordship, this matter first time came before the court on 9/8 and this notification was of 3/8. He has not made any challenge to this notification.
Why do I challenge? It's not different thing.
He has grievance
But
regarding
he's
this
totally out
notification, Lordship.
on a different track.
no,
I did not challenge it,
Just
not
to
even.
delay the
does not have
process- Just to delay the process of the tender.
No. My submissions are online, Milo. It's being aired, what I'm submitting. How could I want for delay? I said 2 days.
So what is your case made out, made out,
That.
in which
issue
paragraph,
My lordships.
pleaded case?
My lord.
In paragraph 14.
Page
please
13.
read, Lordship.
Page 14, paragraph 13. May I read? That it is
Yes.
opposite to state herein that to travel and reach Dibru River Part 1 fishery by waterways, invariably the stretch of Maguri Metapong wetland has to be traversed. This is a fact which is applicable to any participating bidder in the tender process, so ensured by notice ending tender dated 27/2023. As such, the directions passed by the Honorable Court in WPC so and so by the order dated 28/6/2023, directing the Deputy Commissioner Tinsukia in consultation with the DFO Tinsukia Wildlife Division to earmark a road by which the said petitioner society could take the yield of the fishery to the market would hold good for any fishery cooperative society whichsoever secures settlement of the said fishery. Furthermore, the official declaration of a route in compliance of the order dated so and so has to precede settlement of a fishery by way of tender. This is so inasmuch as the bid value is hinged on the expenses to be additionally incurred on a daily basis depending on the route.
No,
So,
whereupon this notification is not in conformity with that order,
that is an additional affidavit.
this notification.
We have filed the additional affidavit. The writ petition was filed prior in point of time. After filing of the writ petition, the additional affidavit came, the notification came, we filed the additional affidavit, my lord.
A detailed route has been
That is a different.
earmarked
I have,
from 6 points.
my lord, the additional affidavit reads
Heard Mr. Asmoni. Counsel for the petition.
paragraph 6 of the additional affidavit, lordship may refer. For a moment, my lord, whatever the order will, I bow down to that, but paragraph 6 of the additional affidavit.
Mr. Esarbo. Counsel for the Junior Government Advocate Assam for the response. Response number 1 to 4. I'll pass order in the impleachment petition. So who are the parcels?
One is
Mr. J.I. Borbunia, learned counsel for the
caveator.
newly impleted caveator stroke newly impleted party respondent number 5 stroke caveator, and Mr. ABT Hawk, learned counsel for the caveator stroke newly impleted party respondent number 6.
Dispose of the petition. Dispose of the petition. Whatever, like that, because notice would again create a problem for them.
Let him withdraw, my lord. A premature stage he came.
Yeah, absolutely no.
As
This
if
is
like this.
premature.
As if like this,
Observe
my
that-
lord, I am a aspirant of MBBS. I do not know. I'll get Chandigarh or Madras. Can it be like this, my lord?
Lordship, page 15, 7 line, Lordship. He has stated that the petitioner is not challenging the issuance of the notice inviting tender dated
Correct.
27/23.
Correct.
No, he said
I said that.
Then why he has filed, my lord?
In the
Then-
fair is
The- by a tender notice dated 27/2023.
Tender process to solve.
The respondent number 4. As the tender inviting authority, has invited bids from intending bidders for settlement of a fishery named Dibru River Fishery Mohol Part
1.
1, a 60% category fishery for full stop. The tender notice has mentioned that the same is issued in reference to the direction made in order dated 15/5/2023, passed in a writ petition WPC number 520/2022 and an order dated 19/7/2023 of the Fishery Department, Government of Assam. Full stop. It is apposite to mention that the fishery for short portable, the fishery was being run on daily basis arrangement since 3/1/2022. Full stop. The writ petition, WBC number 728. Is it so?
Actually, and some.
Huh?
Lordship,
Or 520
absolutely.
stroke 2022 was preferred. Challenging such daily basis arrangement. On the ground that regular settlement of the fishery was not done by the respondent authorities. And the same was in violation of the provisions contained in Rule 12 of the Assam Fishery Rules 1953. So after hearing the learned counsel for the parties in the writ petition, along with another writ petition, WBC number 728/2022. The two writ petitions were disposed of by the order dated 15/5/2023. So from a perusal of the order dated 15/5/2023, it transpires that the same is a consent order whose the state respondents were directed to make regular settlement by the state order dated so and so. The state respondents were directed to make regular settlement of the fishery within 1 month from 15/5/2005 and to complete the entire settlement process by issuing a tender notice and selecting the successful tenderer within a further period of 1 month. Full stop. The order dated 15/5/2023 Supra made it further clear that the daily basis arrangement of running the fishery should continue only till 15/7/2023. Full stop. After passing of the order, it is 15/5/2023, the Fishery Cooperative Society who was running. No. What is the order?
79 it starts.
No, that's
The second one,
withdrawal of road.
87. it
After
starts,
passing of the
93.
order dated 15/5/2023, the District Fishery Development Officer Tinsukia
86.
wrote to the Fishery Department, Government of Assam, by communication dated 35/2023, stating that the permission granted earlier to the lessee of the fishery who was running the same on daily basis, for places to sale point of fish in Dhola Bazar, page 86, Roman 1, Dhola Bazar, Roman 2, Dighal Torong Ghat, 3, Silika Ghat, 4, Gujan Ghat, and 5, Dinjan, through vendors with passes through Maguri, Metapang wetland had been withdrawn with immediate effect until further instruction. Full stop. Agreed by the order of withdrawal of the passes to the sale points of fish for those 5 number of locations on and from 35, 2023, comma, the Fishery Cooperative Society, VIZ, Messrs. Dibru Damori River Part -1 Mean, by Committee Limited, comma, represented by Mr. ABT Hawk, Learned Counsel, comma, preferred a writ petition, comma, WBC number 3699, 2023. Full stop. The writ petition, said writ petition, comma, WBC number 3699, 2023 came up for consideration on 28/6/2023. Full stop. The court, after hearing the learned counsel for the parties, disposed of the writ petitions with certain observations. Full stop. The court, observing that the party respondent number 6 hearing was running the fishery on daily basis and was allowed to continue up to 15/7/2023, comma, the respondent authorities should earmark a route by which the said society could take the yield of the fishery to the market. Full stop. The order dated 28/6/2023 directed the respondent authorities to take a decision to that effect within 10 days from the date of receipt of the certified copy of the order or before or 12/7/2023, comma, whichever was earlier. Full stop. It was further observed that it was further made clear that the temporary arrangement of running the fishery on daily basis shall not be extended beyond 15/7/2023, comma, the timeline prescribed by the order dated 15/5/2023 passed in the writ petition WPC number 520/2023. Full stop. In the backdrop of aforesaid sequence of events, comma, it is evident that the caveator stroke the party respondent number 6 society hearing was not allowed to operate the fishery on daily basis beyond 15/7/2023. Post. Para. The petitioner has preferred the writ petition seeking inter alia direction. Seeking inter alia
Page 17.
setting aside of the tender notice dated 20/07/2023 issued by the respondent number 4 in respect of the fishery. Full stop. The petitioner society has also sought for a direction to the respondent authorities to fix and declare the submission of bids to a date so that the respondent number 4 in consultation with other authorities declare a basis stroke route as directed by the court by the order dated 28/6/2023 passed in the writ petition WBC number 3699/2023. It is the contention of Mr. Bonik, learned counsel for the petitioner, that the MS Mr. Borua, learned junior government advocate Assam. No, Mr. Bonik, learned counsel for the petition has submitted that the respondent of 4 has in the meantime issued a notification dated 3/8/2022 3 annexed as annexure 1 to the additional affidavit, declaring a passage or declaring a road stroke route to reach the sale points of fish at 1, 2, 3, 4, 5 is 112. Then within bracket, without breaching the eco-sensitive zone of Dibru-Soikhwa National Park / Biosphere Reserve, the notification dated 3/8/2023 is purportedly in deference to the order dated 28/6. Notification has mentioned that the same has been issued purportedly in deference to the direction made in the order dated 28/6/2023 passed in WBC number 3699/2023. Mr. Boarding, learned counsel for the petitioner, has contended that the route to reach the 5 number of sale points of fish, mentioned in a notification dated 3/8/2023, pertain to are nearer to.
Not nearer. It is from that point. It is from Brahmaputra part 1 and Dibang River section.
Nearer to the other fishery, right?
My lord. It is from that point, which is with
It's
the
page 86.
page 86.
Page 86. Let us see. Are nearer to Brahmaputra part 1, Roman and Dibang Nodi fishery, and are not nearer to the fishery.
Which is 40 kilometers away.
Not nearer to fishery, F capital. That is Dibru part 1 fishery. So it is, he has contended that the two fisheries, that is Brahmaputra Part 1 and Dibang Nodi Fishery and Dibru Part 1 Fishery are separated by a stretch of 40 kilometers.
Land.
That is your case.
Gotcha.
He has contended that until a clear road stroke route, then sale points are different then.
My lordships, sell points, it's not the lessee who has the right. Both the lessees can come to sell at the same sell points, but to reach, there will be two different land routes. That's what I'm on. 40 kilometers away, two different routes have to be.
Route stroke road stroke route for the sale points from the fishery activity is not declared, comma. There will be several difficulties. Several the intending bidders would respond to the tender notice dated so and so, comma, would face several difficulties, and the bidding process might result in lesser amount to the state exchequer. He has sought, the petitioner has contended that until such road stroke route is declared by the respondent of poor society, comma, the tender process initiated by the bidding process initiated by the tender notice
The last date in time.
dated 27/2023. The time period, timeline for submission of bid in response to the tender notice dated 27/2023 be extended till such time. This is your case.
That's-
That is good.
that's- We are not even praying for a stay or.
Mr. Orvia, Mr. Hawk, and Mr. Burua have submitted in similar lines. So their contention is that the bidding process initiated by the tender notice dated 27/2023 shall not be interfered with,
And has to come
permitting
to
the bidders
has to come to the logical conclusion.
so that they interfere with at this stage. Comma, permitting the bidders to submit their respective, intending bidders to submit their respective bids. Full stop. It is their contention that the grievance raised by the petitioner cannot be envisaged at this stage, as the petitioner has not yet submitted its bid in response to the tender notice dated so and so. Full stop. In any view, they have contended that in any view of the matter, comma, it is for the successful bidder it is for the bidder who will emerge successful after the bidding process, comma, can raise such a grievance. Issue notice returnable in 4 weeks. As so and so appeared accepted. No formal notice. Extra
One more-
copies within 2
One
working
more
days.
I like to add, my lord, before your lordship, my lord, the interim prayer made by the IN was not considered, my lord. Otherwise, my lord, the state authority may misinterpret.
Huh?
The interim
He's
prayer
thinking
lordship
for-
did not consider that
But
observation
legal case is
making
different.
at this stage, my lord.
It is observed that having heard the learned counsel for the parties, comma, it is observed that the tendering authority, respondent authorities shall proceed with the bidding process initiated by the tender notice dated so and so. And the order shall not be construed as
For logical conclusion.
shall not be construed that this court has interfered with the said bidding process.
Lordship.
Okay, I have to pass this IA also. Heard Mr.
But the extra copies need not be given because they are parties. we have
2
signed.
days,
We have
2
signed.
days. IS 24012 your, okay. ZI Bormia.
01.
But so far, Mr. Barbuya is concerned, he got the copy on KVL.
Yes, I'm not
So far-
insisting.
Yeah, let me pass the order.
I'm not insisting for copy, my
Learned
lord.
counsel for the
Please
applicant.
read, my lord.
Mr. SR Borua. Sorry, Mr. S. Boni. Learned counsel for the opposite party, that's lead petitioner. Opposite party number 1, that's lead petitioner. And Mr. SR Borua, Learned Junior Government Advocate Assam. For the opposite party number 2 to 5, full stop. The instant application, interlocutor application is preferred, seeking improvement of the applicant as party respondent number 5 in the writ petition WPC number 4494/2023, full stop. The writ petition, WPC number 4494/2023 has been preferred in connection with a tender process, tender notice dated so and so, issued by the Deputy Commissioner Tinsukia, whereby bids have been invited for settlement of a fishery named Dibru Nodi.
Not the part one. fish.
Part 1 fishery. Full stop. As the applicant is an intending bidder.
An immediate neighbor also.
Huh?
An immediate neighbor also.
Is an intending bidder to the bidding process initiated by the tender notice dated so and so. And the writ petition has been preferred in respect of the said bidding process. The petitioner has sought its implement as a party respondent in the connected writ petition. Having Mr. Bonik, learned counsel for the opposite party number 1, the writ petitioner has no objection to the prayer for implement. Full stop. I have gone through the statements and amendments made in the application and has found that this applicant has made out a case for its implement as a party responding in the connected petition. Accordingly, the instant application is allowed the office to cause necessary correction in the cost title of the connected writ petition by implementing the applicant as party respondent number 5. Same thing order ABT hub instead of JI Bormia, ABT hub. Opposite parties are same.
6, same only.
Silo. Bonik is number 1. opposite party, okay, same. 6, party response number 6.
Reference.
Am I successful that? Am I successful? Then raise the grievance. There is no road.
Item 6.
Yeah, Mr. Bonik, you are putting the cart before the horse. Yeah. The present writ petition. The petition has been preferred. Challenging. One, two, three, four, take it, you know. 1. Order dated 21/7/2009. 2. Order dated 8/9/2010. FIR is writ petition criminal. FIR either 482 or writ petition criminal, not writ petition civil. So I'll not include. And order dated 3/7/2012 passed by the respondent authorities in the Employees Provident Fund Organization, EPFO. Full stop. (21/7/2009). By order dated 21/7/2009. Comma. You have not made him party? The petitioner sorry. It has been held that no, the order dated 21/7/2009 is an assessment order whereby the respondent EPFO has found that an amount of rupees 8,02,65 is found due from the petition number 1, comma, Messrs. DIMS Hospital as dues under the Employees Provident Funds and Miscellaneous Provisions Act 1952 for the period from May 2004 to February 2009. First stop. By order dated 8/9/2010. Direction as in mid. To the respond number 3. To recover an amount of rupees 7,61,796 and the petitioners have been restrained until from receiving and the said order is in the nature of a prohibitory order. T7/2012. T7/2012. By order dated 3/7/2012, the petition number 2, who is the managing director of the petition number 1 establishment, was directed to remit an amount of rupees 6,14,527 in favor of the respond number 3. Within 10 days from the date of receipt of the said letter or said order, failing which necessary actions under the provisions of the Employees Provident Funds and Miscellaneous Provisions Act 1952 would be initiated for realization of the same without further information. Paragraph. The petitioners have averred that the petition number 1 is a unit of Mayflower Healthcare Private Limited. And it runs a hospital named Deems Hospital within bracket Thorindhor Memorial Institute of Medical Sciences and Research. Para 2. Post. Within bracket the hospital. as the hospital was an establishment under the Employees Provident Funds and Miscellaneous Act 1952 within bracket লিখি দিব EPF Act, the Act for short. The same was brought under the purview of the Act with effect from 1/4/2004. With and it was assigned a code, PF code number -AS/5614. Full stop. As per the pro forma for coverage submitted by the petition number 1, the total number of employees in the establishment at the time it was brought under the purview of the Act was 28. Full stop. I have heard Mr. Adhor, learned counsel for the petitioners, anyway, CGC, and Mr. P.K. Roy, learned senior counsel, assisted by Mr. M. Doctor, learned counsel for the response number 2 and 3. Mr. Dhor, learned counsel for the petitioner, has submitted that though the hospital started its functioning in the right earnest, an untoward incident took place on 19/5/2003, and the same incident led to an order and the same incident had ultimately resulted into an order dated 35/2023 from the State Health Establishment Authority, whereby the state government, whereby the state authority directed its closure. Full stop. The sequence of events, the events thereafter, resulted into arrest of the petition number 2, who was the managing director of the hospital stroke establishment. The functioning of the hospital stroke establishment was severely affected, and there was exodus of employees for other engagements elsewhere. Full stop. as the number of employees in significant numbers had left the hospital stroke establishment, the number of employees in the hospital stroke establishment came down below 20. Full stop. Despite all odds, despite all such odds, ODDS, the hospital authorities, with the hope that things would turn around, continued to retain the Provident Fund registration with the EPFO authorities and did not formally close down the establishment. Despite the order of closure from the State Health Establishment Authority on 30/5/2003. Full stop. Mr. Torres submitted that the petition number 2, being a doctor by profession, had utilized the premises for consultation, but no, full stop. As it faced severe financial crisis, the hospital stroke establishment failed in depositing the dues under the Act with the respondent EPFO authorities in time. Full stop. So in time for the period from 2004 to 2009, right? Full stop. The same led to initiation of a proceeding before the Assistant Provident Fund Commissioner within bracket compliance. Regional Office NER bracket or return Guwahati under section 7A of the Act. Full stop. On receipt of notices, the representatives of the hospital stroke establishment appeared before the said authority. And tried to bring the situations then faced by the establishment, hospital stroke establishment, and with such representation, there was a prayer was made for waiver of the PF Provident Fund dues on the ground of financial crisis. Full stop. The Assistant Provident Fund Commissioner Compliance had, however, no, had did not pay any heed to the difficulties expressed by the petitioners and had gone ahead to determine the statutory dues under the Employees Provident Fund Scheme, 1952. Employees Deposit Linked Insurance Scheme, 1976, and Employees Pension Scheme, 1995. Mr. Dhar has contended that such statutory dues were calculated at 5,81,708 under the provisions of Section 7A of the Act, and in addition, the said authority had also imposed penal interest to the extent of rupees 2,18,557 under Section 7Q of the Act. Full stop. The determination which was purportedly made on the basis of an inspection report, was arbitrary. Full stop. After passing of an order dated 21/7/2009 by the under Section 7A of the Act, the petitioners submitted an application, submitted a, how you have styled it, review.
Appeal below.
Huh?
Appeal. It's not review. We have specifically said there is no
Page 45.
page 45,
Yes, 45.
humble review. This is one second page also, next petition also.
45, right?
Appeal, no?
This is neither here nor there.
And
Basically representation.
Page 48, my lord.
45 is representation.
48 specifically said appeal.
Representations dated 14/9/2009 and dated, what is the date?
It's 2/4.
2010.
2/4/2010. Before the respondent authorities in the EPFO to reconsider the demand made by them as regards the statutory dues by the order dated 21/7/2009. Full stop. The petitioners had represented that the hospital stroke establishment had been facing severe financial crisis subsequent to the service of closure notice in May 2003 and exodus of doctors stroke employees from the hospital and Marseille. Full stop. It was further represented before the respondent EPF authorities that the hospital stroke establishment had to repay a substantial loan to the financial institution. Full stop. The respondent authorities, as the respondent, no, sorry, but no heed was paid to those representations, and the respondent authorities had issued a so-called notice on 23 to 2010. Directing the hospital stroke establishment to show cause as to why legal action and prosecution under section 14 of the Act should not be initiated for non-compliance of the order of the assessing authority dated order of the assessing authority passed under section 7A of the Act. Full stop. Thereafter, a notice of demand dated 5/5/2010 and a prohibitory order dated 8/9/2010 were passed. Full stop. And a first information report was also lodged before the officer in charge, Nunmati Police Station, and the same led to registration of any police case?
Yes. 17 of 2011.
Nunmati Police Station case number 17 of 2011.
11.
Mr. Dhar has pointed out, has drawn attention to the contents of the affair to submit that in the FIR, the respondent authorities had mentioned about defaults of rupees 3,97,526. But later on, the same authorities in its order dated 3/7/2012, had mentioned about rupees 6,14,527 as area dues. Such discrepancies as the amounts mentioned in the FIR data date to yes FIR tool 13/1/2000. In the FIR, the figures mentioned Now, he has contended that the figures mentioned in the affair and the order dated P7/2012 are at variance. And the same makes it clear that the respondent authorities have not proceeded with the matter by proper calculation of the statutory dues. In rest of the establishment, hospital stroke establishment. And what are the other grounds?
Well, we have asked for to payment dues, page 58,
It is, Mr. Dhor has submitted that the
monthly by statement.
petitioners had made deposits from time to time with the respondent EPFO authorities. But the respondent EPFO authorities have not provided statements indicating how different figures have been arrived at by them at different points of time. So as a result, the petitioners are not in a position to find out the correctness of the demands made by the respondent EPFO authorities. Correctness of the demand?
Correct, sir. As per order dated 3/7/12.
And that I have already. Yes, Mr. Roy, what is the case? Mr. Per contra. Mr. Roy and his senior counsel appearing for the respondent EPFO authorities have contended that the hospital stroke establishment itself in the pro forma for coverage had declared that it had 28 number of employees as on January 2005. Full stop. It was never the case of the hospital stroke establishment that the hospital stroke establishment had closed, was closed, had been closed forever, was not functioning, and was closed forever. Full stop. When the proceeding was initiated under section 7A of the Act, the representatives of the hospital stroke establishment had even in their so had not projected in the aforesaid manner, but had submitted a representation for waiver of the statutory dues on the ground of financial crisis.
No power for it.
Huh?
We have no power, we don't- power is the.
He has contended that the enforcement officers for the purpose of ascertaining the views of the hospital stroke establishment made inquiries and thereafter submitted an inspection report. Full stop. The assessing authority, that is the Assistant Provident Fund Commissioner Compliance, before passing the order dated 21/7/2009, had considered the case of the hospital stock establishment as well as the inspection reports submitted by the enforcement officer. It was after such consideration, the assessing authority had arrived at the figure of statutory dues for the period from May 2004 to February 2009, and the respondent, and the petitioners have never challenged the manner in which have never challenged seriously the manner in which the said figure was arrived at by preferring either any appeal or any review as per the provisions of the Act. Full stop. Though he has contended that it is projected on behalf of the petitioners that the representations submitted by it were in the nature of review, the same cannot be termed as either review or either appeal or review, as a review or an appeal. To be termed so, is required to conform with the provisions of the Act. Full stop. He has submitted that the variance, the two figures mentioned, sorry, the figures mentioned in the affair and the order dated 3/7/2012 are different for the reason that in the affair, only the employee's share was mentioned. I have given due consideration to the submissions of relevant counsel for the parties and have perused the materials brought on record by the parties to their pleadings. Full stop. It transpires that the hospital stroke establishment itself submitted a pro forma for coverage along with the essential documents before the EPFO authorities. Full stop. On stating that as on January 2005, it had employee strength of 28. Full stop. The pro forma of, as per pro forma of invoice, the hospital was commissioned on April 2003. Full stop. And full stop, though it mentioned that the functioning was irregular and intermittent up to March 2004 due to court cases. But with utmost difficulty, the hospital stroke establishment started to function from April 2004 onwards. It had declared its business activity as nursing home with healthcare activity. Full stop. It had further declared in the pro forma of invoice, that wages disbursed for the month of January 2005 was around 1.55 lakhs. The details of the 28 number of employees were also indicated in the said pro forma of invoice. It was on the basis of the said pro forma of invoice, the EPFO regional office, Northeast region, Guwahati, brought the establishment, hospital stroke establishment under the purview of the Act by order dated 11/2/2005. By and allotted code number AS/5614 to the hospital stroke establishment for the purpose of compliance with the various provisions of the Act. Full stop. The order dated 11/2/2005 further had reported that the same was the hospital stroke establishment had been brought under the purview of the Act on the basis of the particulars furnished by the hospital stroke establishment and on the basis of inspections of the records of the hospital stroke establishment by the enforcement officer on 4/2005. The order dated 11/2/2005 had further mentioned that as the hospital stroke establishment completed the infancy period, the Act would be applicable to the hospital stroke establishment from 1/4/2004. When the hospital stroke establishment defaulted in its payment of the dues under the Act, the assessing authority, that is the Assistant Provident Fund Commissioner, initiated the proceeding under Section 7A of the Act for determination of monies due from employers. Full stop. There are four ready reference, comma. The contents of section 7E of the Act is quoted here on the. Full stop. From perusal of the order dated 21/7/2009 of the assessing authority, it is noticed that the inquiry was initiated. It is noticed that the hospital stroke establishment was initially issued a notice under section 7A on 19/7/2007. Full stop. The date of hearing originally fixed on 29/8/2007 and subsequently adjourned to hearings originally fixed on 29/8/2007 and subsequently adjourned to 27/9/2007, could not be held due to absence. Due to non-appearance of the authorized representatives of the hospital stroke establishment. Full stop. The hospital stroke establishment was again issued notice under section 7A of the Act on 7/8/2009 and in response to the same notice, two authorized representatives of the hospital stroke establishment appeared before the assessing authority on 6/7/2009 and submitted a representation for waiver of the statutory dues on the ground that it was facing financial crisis. The hospital stroke establishment was facing financial crisis. Full stop. The said request was considered by the assessing authority and was rejected on the ground that the hospital stroke establishment had not shown any compliance since May 2004. The assessing authority went ahead with the inquiry by considering the inspection report submitted by the enforcement officers. Full stop. From the details of dues from the table regarding details of dues, it transpires that the assessing authority considered had taken a sum of rupees 52,767 as wages for the month of May 2004. Wages payable to the employees of the hospital stroke establishment for the month of May 2004. Full stop. The said the figures under the head wages were different. In different months But it showed, but it recorded a declining trend under the head wage during the period from May 2004 to February 2009. In February 2009, the assessing authority had recorded a sum of rupees 13,930 under the wage head. So it is going down. So does not indicate that it is arbitrary. It was on the said basis, the assessing authority had arrived the assessing authority, after having gone through the documents placed before him, assessed the dues for the period from May 2004 to February 2009 at rupees 8,265,000. Full stop. The said sum said about the rupees 8,265,000 comprised of rupees 5,81,708 was dues payable under section 7A of the Act, and rupees 2,18,557 was penal interest under section 7Q of the Act. Full stop. The order dated from the order dated 21/7/2009, it is noticed that the assessment was made. So sorry, the figures are up to the date of assessment and would be increased till the date of actual payment and production of the deposit challan. Full stop. Paragraph. The section 7B of the Act has provided for review of orders passed under section 7A. Whereas appeal
7I. 7I.
section 7I has provided for appeal to has provided for appeal. The order dated 21/7/2009 was subject to either review or appeal. Full stop. A review under section 7B an application for review under section 7B is to be filed in such form and manner and within such time as may be specified in the scheme. What is the scheme? Somewhere mentioned.
In their affidavit, they have
Somewhere, huh? Yes.
7B, 7, Form 7, Form 9 is the review.
Which part?
This book,
Page 5.
No, in your affidavit.
yes.
Huh. 79A paragraph. Huh?
79A of the scheme.
Paragraph 79A of the APF scheme 1952 has provided that any person agreed by an order made under subsection 1 of section 7A of the Act and who desires to obtain a review of such order may apply for a review of that order, comma, as provided in subsection 1 of section 7B of the Act in Form 9 to the authority who passed such order. Full stop. It has further provided that no application for review of an order would be entertained by the concerned officer unless the application for review is submitted within 45 days from the date of making such order. Full stop. On the other hand, comma, as per section 7I, comma, any person aggrieved by an order passed under subsection 1 of section 7A may prefer an appeal to a tribunal against such order as per subsection 2 of section 7I, comma, every appeal filed under subsection 1 shall have to be filed in such form and manner, comma, within such time and be accompanied by such fees, comma, as may be prescribed. Full stop. The representations stated to have been filed by the petitioner, comma, on
14/9/2009
14/9/2009 and
and 2/4/2010.
On a scrutiny of the two application representations stated to have been filed on so and so on behalf of the petitioner in the nature of review or appeal do not conform to the provisions of either section 7B or section 7I of the Act, either in form or on the point of limitation. Full stop. On as regards, also as regards compliance of deposit of necessary fees. Full stop. The non-deposit of statutory fees assessed statutory fees under the Act, assessed by the order dated 21/7/2009 of the assessing authority have led on the part of the petitioners that is the hospital stroke establishment, have led to the issuance of the show cause notice dated 23 to 2010. Comma, the notice of demand to defaulter dated 5/5/2010 by the recovery officer in accordance with the provisions of sections 8B to section 8Z of the Act and the prohibitory order in form EPFC-3 dated 8/9/2010 by the recovery officer under the said provisions by treating the hospital stroke establishment as deemed defaulter. Full stop.
My lord, lastly, the 3/7.
Coming to that. The petitioners have not been able to show any infirmity in respect of either the show cause notice or the notice of demand to defaulter, literally keyword, or the prohibitory order dated 8/9/2020. Full stop. The contention as regards discrepancy in the figures of area dues appearing in the FIR dated 13/1/2011 and the order dated 3/7/2012 appears to be a misplaced one, as the respondent EPO2 authorities have explained the reason as to why the figures mentioned in the FIR and in the order dated 3/7/2012 were at variance. Full stop. In the FIR, as per the EPFO authorities, the figure mentioned in the FIR was in relation to the employee's share of PF contribution which was rupees 3,97,526. Full stop. On the other hand, the amount of rupees 6,14,537 mentioned in a notice dated 3/7/2012 was for both employee share and the employer share of PF contribution, and also interest payable under section 7Q of the Act. Full stop. in the backdrop of aforesaid, the contention of the petition has advanced on behalf of the hospitals to establishment that in course of time, there was since in the course in course of time, there was exodus of employees from the hospitals to establishment and masse is not acceptable in view of the provision contained in subsection 1 of subsection 5 of section 1 of the Act and the statements made by the hospital stroke establishment itself in the pro forma of what is the name? For coverage. Declaring its position as on January 2005. Full stop. As per subsection 1 or 5 of section 1 of the Act, an establishment to which the Act applies shall continue to be governed by the Act, notwithstanding that the number of persons employed therein at any time falls below 20. Right? There is a position.
But only one thing I just point out, in the notice of demand of defaulter, it was issued on 5/5/2010. It was 7,61,296. And if we go by the affidavit, paragraph 5 of the affidavit, there are two figures. One is 3,97,526 for employees' contribution, and in the notice stated 6,14,000. If we calculate both the things, within a span of 2 years, it comes to 10,12,053 rupees. Although in the between, we have paid lots of money.
How much figure that will be in the penultimate para? See, 3,97,000. This is one share.
Employees share.
And another amount would be employer's share. If it is employees, the other part will be employers.
That is why we are asking them to give us a
Right.
statement.
Then in the meantime, you have deposited some. There will be some mechanism that if something is received, right, it will be adjusted against that head,
Exactly.
right? There is some mechanism. Suppose you have taken a loan and it carries interest. Now you have defaulted in the EMI, right? Now in the next month you pay the amount. It will be adjusted against interest, not against the principal.
Exactly.
Like that, there is some mechanism
Just
which
only
they
fair-
will be provided. I'll direct them to provide the exact calculation,
Exactly.
but on the base substantive,
And-
on the
and-
point
and
of law, I don't
I
think
concede.
you have a case.
I concede to that.
So I'll make the direction, give a proper calculation as to how and against what head they have adjusted the figures and arrived at a calculation up to the date of this 3/7/2012 and thereafter. Up to 3/7/2012, how they have arrived at that figure, right? And also for the period thereafter till date. That will do.
That will do.
I think every doubt will be clear. Then if you can challenge also by filing appeal. Right. Equal. Yes, Mr. Roy, you have mentioned about one decision.
This is.
Do you have the copy?
Yes, yeah, I have a copy. Bro.
Let us see.
My lord, financial crisis and all.
Okay, financial crisis.
This cannot be a criteria. That organo, my lord, is the long back.
Okay.
This relied on organo, my lord. There are 17 of this, my lord. This relied on organo.
There are 17.
There are 17 of this.
Organo.
Organo, the earlier organo is also here, no? Organo-
What is this? Hindustan Times?
Hindustan Times. There is report in SCC also.
Yeah, mentioned in,
In affidavit,
in your,
affidavit
affidavit.
also.
Here it is paragraph.
Here in this case, para 17. Hindustan Times. Para.
Paragraph 17.
Of that, the Hindustan Times judgment I've given.
Oh, Hindustan. No, about organo?
Organo, मतलब para, I will give you lot. Para to the body. Para casting organo.
Failure in payment rejected. Paragraph?
Para 17 in that judgment, no? Organo, I look at.
Paragraph 17.
Yes,
In
of
Hindustan.
Hindustan. This
Paragraph
organo,
17. Okay.
because
It has been held.
it is breach of trust.
The plea. The explanation provided from the end of the hospital stroke establishment that the statutory dues under the act as determined by the order dated so and so of the assessing authority, could not be paid. And on the ground of financial crisis faced by it, and sought its waiver for the same reason, is not acceptable in full stop. It has been held in Hindustan Times Limited versus Union of India and others, reported in 1998 to SSC 242 that the obligation to pay the statutory dues into the fund of the EPFO under the provisions of the Act is unqualified. Full stop. The explanation of the employer that the default was due to financial problem faced by the establishment was held, has been held to be not acceptable. Anything is left? In the light of the above discussion and for the reasons assigned, the challenge made by the petitioners in the instant writ petition to the orders, mentioned above, are found not sustainable. Full stop. Consequently, the writ petition is found to be bereft of merit, and the sum is liable to be dismissed. Full stop. It is accordingly dismissed. Full stop. During the course of his submission, Mr. Dhor and counsel for the petitioner has submitted that the petitioners, the hospitals took establishment where was never provided a statement of accounts by the EPFO authorities detailing as the manner as to how the adjustments were made by the authorities against the payments received from the hospital stroke establishment from time to time till 3/7/2012. And as such, the petitioners, the hospital stroke establishment was not in a position to find out the exact nature of liabilities under different heads. Full stop. Mr. Dhor, he has further submitted that apart from a statement up to the order dated 3/7/2012, the respondent authorities should also provide the statement regarding the liabilities for the period thereafter. Full stop. In response, Mr. Roy,
I'll instruct.
learned senior counsel appearing for the respondent EPFO authorities has submitted that if any application is received from the hospital stroke establishment outlining the details about the statutory dues, payments received, adjustment made, etc., will be provided to the hospital stroke establishment to the extent permissible within a reasonable period of time.
After receipt of.
After receipt, right? In the event,
Yes.
Mr. Dhor may choose not to file an application also
Yes.
within a reasonable period of time, preferably within a 4 weeks period of 4 weeks.
Thereafter.
Within thereafter.
Clause.
Full stop. In view of such broad consensus arrived at by the parties on the appropriate aspect, this court, there is no necessity to observe anything further except observing that the parties, the respondent EPFO authorities will act in the manner submitted above. That will do.
In fact, in the morning, I was thinking to settle it outside court with the.
It is not a matter, my lord, it is a statutory.
So, but it will take
Definitely,
2-3
we
days
have to
time.
pay. We have to pay it because it's.
Ah. It will take 2-3 days time. Tomorrow, day after tomorrow, I have some other engagements. Take one with you. You need this one.
No, I will take it.
2012, 11 years.
Obliged.